Court, she just appeared, and you were first on the docket, and maybe the others think it might not be fair for me to take you, but please, you got a default hearing, and if you can brief me on that, we can move on your case.
Yeah, sorry, Judge. I was on Microsoft Teams for some reason. I don't know why it connected to your connection there.
We have a defective connection because I'm listed as a bailiff, and I had to switch here, and I don't know what the county did that I can't be heard from my computer. But please proceed.
Thank you. This is a motion for default judgment on behalf of ROP Rio Zaragoza LLC. Ms. Aguirre entered into a lease with my client in May of 2022 to lease space for a period of years. She defaulted under the terms of the lease. We exercised our obligation to mitigate damages, and the amount that we're seeking is the balance that remains after those efforts were concluded in the amount of $19,530.68. We have attached the affidavit of the client, as well as which incorporates the lease, as well as the accounting of what remains and how that amount was determined, as well as a affidavit in support of attorney's fees. And we would ask the court to enter judgment. I believe a proposed judgment was forwarded to you when we sent you the motion itself to get this matter set.
Yes, sir. Can you tell me about the service on this case?
Yes, I can. It was, hold on one second. And notice was given to her for this hearing. Just,
well, she didn't enter an appearance. That's the basis of your default, but.
Correct.
Yeah.
Yeah, there's a return that was filed on November 10th in this matter. And it was served to her at 3092 Coyote View Place in El Paso at 6:21 p.m. it looks like.
Okay. Are you asking for any attorney's fees?
We are, Judge, for $4,000 in attorney's fees, and there's an affidavit in support of that.
Yeah. Well, your packets are usually complete. All right. So, Cindy Aguirre, are you here, or is anybody here on her behalf? Robert, can you check and see if anything got filed with the district clerk? Mr. Schwartz, I've said this numerous times. A lot of times something will get filed and you wouldn't know because nothing was sent to you. So I'm going to have Robert. Yeah.
That's fine, Judge.
It'll only take him a minute.
There was a serviceman's affidavit filed yesterday as well, Judge.
Explain what the serviceman's affidavit is.
That she was not in the military during the period of time that we're.
Okay. Yeah, military. Okay, I used to hear the military service affidavit. You said serviceman. It doesn't matter. You're the expert. I had one filed, and I was moving along, and then all of a sudden the pro se answer is, "Hey, I'm in the service." I'd never had that happen to me before. A lot of times, I don't know how you check on their military status when you file that, but I'm sure you do it with required due diligence.
Yeah, there's a website.
There's no answer, Judge.
No answer file. Okay. So submit. I know that you may have already sent it, but just to get it done, if you submit the judgment to Robert, it ought to get signed before the end of next week, maybe even today.
Great.
And then of course tell your staff not to hesitate to call us if something didn't happen that we were supposed to do.
Every 10 minutes, Judge.
Yes, sir. Listen, do you have another case on here?
I don't.
Okay, I don't know if I've run into you, but have a happy New Year.
Same to you, Judge. Thank you very much. Bye-bye.
Okay, next. I have Derek Jenkins versus Demetrio Chavez Jr. and Tibet Enterprises, Inc., DBA Ameritrans. And this is for a sanctions hearing. May I have announcements of counsel, please?
Good afternoon, Your Honor. This is Colin Jacobson representing the plaintiff, Derek Jenkins.
Is it your motion?
It is, Your Honor.
Okay.
And Your Honor, Aldo Lopez on behalf of the defendant.
Okay, I have Daniel Hernandez. Are you here? Has there been a change? Are you with him?
No, so yeah, I'm covering for Dan. Dan's currently in a hearing in County Court 7, Judge.
Okay. No issue with you covering for him because I know you're a licensed attorney. All right, Mr. Jacobson, please brief me on the sanctions request.
Absolutely, Your Honor. So we are here because for 1 year now, we've been trying to get the defendant, Demetrio Chavez Jr.'s deposition. We first asked for dates in January of 2025.
Okay, listen, let me, I'm sorry, I will get the details. I understand now what's happening, but so what's the sanction? What did they do for you to file a sanction request?
Certainly. So they have now advised that Mr. Chavez is no longer in communication or cooperating with them, and therefore we can't get his deposition. The discovery deadline ends here next month, I believe. We have expert deadlines next week, and we've been trying to get this deposition for a year. And so at this point, Your Honor, we believe the appropriate remedy is to strike his answer if he's not going to participate in this case. And exclude him from testifying in this matter. Because the concern, Your Honor, is they're going to magically find him on the eve of trial well after discovery's been closed and try to surprise us at trial with him when we haven't had the opportunity to depose him, despite our good faith efforts to do so. So that,
So,
in a nutshell, is the issue, Your Honor.
all right, so you're asking me to make a lot of assumptions and then assume that they're true or make a finding that they're true, but some of them are speculatory or would require evidence. So let me just try and clarify some things. The discovery deadlines are under my discretion, correct? Or by law, are you going to be foreclosed from any kind of relief you want because you didn't do something by a certain date once the case was in my court?
The deadlines are based upon the signed DCO that was signed
Okay,
by
please, we're on the record and other people are watching. What's the signed DCO?
a signed DCO is a docket control order that the parties agreed upon dates for different deadlines in your case, or in this case, in your court. That was then signed by the court, setting different deadlines, discovery, expert designations, pleadings, joinder, and a trial date.
All right. Anytime you want Mr. Lopez here personally, if Mr. Hernandez is not going to be an attorney in the case, in fact, or you can ask for that. But before you do all of that, I'm going to kind of explain to you the way that I do certain things. First of all, I always follow the law, and I always recognize any right you want to assert. And the reasons that you stated sound plausible for you to want sanctions against the other side. And I'll seriously consider it once I take into account more detail, because it's not surprising to me that parties are going back and forth like you're supposed to, keeping me out of it, trying to get something done, and then they don't do this and they don't comply with that. So other than your own DCO that you signed together and all, which I can decide on the basis of that, is there an order that I issued that is not being obeyed?
No order, Your Honor.
Okay, so I can keep talking, but I don't want to do that, or I can hear you at the end because I have other people waiting. Have you already gone to mediation on this case?
We have, Your Honor.
Okay, and then can you tell me the result of it?
Way far apart.
Okay. Can you tell me the amount of controversy? As far as not whatever they've proven, but whatever they're asking for and all. No, what you view as the amount of controversy.
We see this as a seven-figure case, Your Honor.
Okay. Thank you. Okay, and then you've already been. Do you have a jury trial setting?
Yes, Your Honor, it's in July of this
Okay.
year.
Are any of the sanction? Are you seeking any sanctions because? See, I can compel. Well, for example, you mentioned that it appears maybe they might not even be uh, in touch with Demetrio Chavez or whatever.
That was
Uh,
specifically told to us. Yes, they have no contact with him anymore since
right.
August of last year.
Yeah. So this is not that uncommon on some of these cases, and so probably they should file a motion to withdraw if they don't want to handle the case anymore. And then we can go from there, and I can hear why I should allow them to withdraw. And I can do that. But I just think that the sanctions and it's a sanction because of a forced procedure that is impossible because this guy can't even be reached with notice. I have no idea about that. I think I'm not saying I'm holding this, but a responsible defense attorney would be filing a motion to withdraw if they can no longer defend him properly because they can't find him. Or uh, you ought to set the discovery deposition or have me order it for cause because they won't agree to it, and I'll do that. But I want to do all this before I start going down the sanctions route.
Your Honor, I would note in March of 2025, we went down that route of just noticing the deposition, and it was met with a motion for protective order.
And
And
then
so,
the protective order never got heard.
it
Okay.
was defense's motion was never heard, set for hearing.
Okay.
That's correct.
All right. So, I have a lot of cases, and a lot of them they keep moving in good faith and also based on the competence and quality of the lawyers involved. But at this point, since it's a 7-figure case, I want to set a status hearing in El Paso in person outside of Zoom so that I can hash all of this out. Or I can I'll set one more status hearing just to see if they're going to remain in the case, and so that I'm going to require Mr. Lopez to be here for that, so that you don't have to make arrangements for local counsel, or unless you want to come down. I'll any of these cases I'll hear in person if both sides want me to do that. But may I suggest that just an intermediate step where I can set a quick status hearing, and Mr. Lopez can tell Mr. Hernandez that he better show up because I said that.
Sure,
And then
Judge,
the other
that's
thing,
sorry.
go ahead.
I was going to say, Judge, so Judge, we don't have a problem with that. So there's two defendants. We represent the corporation and the driver.
Okay.
The driver is the one we're having an issue with. Initially, we did have contact with him, and I know back when they were first requested back in January, we did provide some dates in February. For whatever reason, that the deposition didn't get taken. And we've been trying to get these depositions set since then. I believe Dan's assistant sent over some dates for the corporate rep depot earlier this afternoon. But really, the problem is with the driver. Um, and it's correct that we've lost contact with him. He's disconnected his cell phone. We've sent him emails, and
Okay, let me stop you there real quick. Is this a driver for interstate or international travel?
it's I believe they're a trucking company. Yes, Judge.
I know, but are they set in Juarez in any way? Or
I
Mexico?
don't believe so, but I'm not sure to be honest with you, Judge.
All right. So, Mr.
But and so Judge, for just for today's purposes, the motion asked for a spoliation finding by the court and an inference against us. And I think the court has it correct that there hasn't been a motion to compel, and there hasn't been an order that we violated where sanctions would be appropriate at this time.
Well, he has a motion to compel, so that's what I'm taking up right now. And I'm
No,
trying to
he's got
tell
it.
him,
He's
Oh,
got a
I'm
motion
sorry.
for sanctions, Judge.
Oh, okay. I'm sorry.
And so
And Your
there's
Honor,
been no
exfoliation
motion.
doesn't require a breach of any order.
Well, wait a minute, sir. Please let me manage this hearing, okay? He's got the floor and I have the floor. And if you want to be heard, just say, may I be heard? And I'll call on you, okay?
Fair enough, Your Honor.
I mean, I can deal with that a little bit easier, particularly since we're in Zoom. All right, so he can file whatever motions he wants to file, okay?
Correct.
But
Judge.
but there's a story and a long explanation behind every motion. Well, any judge can run their docket the way they want to run it. I try and accommodate parties, particularly since there's a lot of lawyers now working from out of town. That it didn't used to be that way. I have a policy that I don't hometown, but also I've evolved into that because a lot of our lawyers and a lot of our law firms work in other parts of Texas, and technology and transportation allow that now. Okay, so I try to accommodate the parties through this Zoom process and through their own use of it. Now, if I hit something like this, where not even because it's anyone's fault, but there's other circumstances involved in the case, I like to move it to El Paso so that I can give it all the attention that it deserves, and I can have the parties here so that we can get the case moving. Now, there's already a July jury setting. I would like for there to continue to be one and not have to continue it because the parties aren't ready. And then maybe out of unspoken courtesies, nobody's saying whose fault it was. But now that I know about this, what I was suggesting was if it's not necessary well, you know what? I'm not even going to get into that. I'm going to have an in-person hearing here. The way Robert sends it out is he gives you dates, you select, and I try and get you set at 2 or 3 o'clock in the afternoon so that I have the whole rest of the evening to address this, because I'm usually pretty busy with a criminal docket in the morning. So I can do that, and then you all talk and see if we need to have this hearing. Now, I don't know that it's any advantage to you that he's going to have to hire local counsel to come down here. But also, if y'all can just work it out without me getting involved in that manner. By the time we go to trial, I want all issues resolved. And this issue on the spoliation, who filed that?
I did, Your Honor.
Okay.
The plaintiff did, Judge.
I need to hear that. I need a live hearing for that. And I need a live hearing that I'll set aside, and you call your witnesses or you do whatever for me to make that kind of a finding. And I need to be fully briefed on the spoliation law, because since it reared its pretty head, probably more extensively lately, I'm ready to make any kind of decision that I need to make. And also the sanctions or the outcome of spoliation is so drastic that it might even resolve the case, or I might make findings that it doesn't need to. I'm doing all the talking. Sir, you may respond, Mr. Jacobson, except to tell me, I would prefer to discuss all the nitty gritty and all, but not here in person. But if you have anything to suggest, for example, that you think you can talk about it or not even address that, let's just get moving to try and get this case done by July so nobody has to file a continuance.
Sure. Yeah, I agree. I don't think we need a continuance of any kind. I'd like to get this tried in July, and if that requires I fly out there for an in-person hearing, let's do it.
Or your local counsel, yeah. Let me see here. And then all the more reason that if you're going to be coming in, and Robert, make a note of that if he is, there shouldn't be any reason for this hearing to get arbitrarily postponed or, for my convenience or anybody else's. Let me see what else I can cover right now. Well, obviously you guys are going to keep talking. And, the missing defendant. Somebody please brief me without any without any commitment that you're 100% accurate. But when you have a corporate and a driver defendant, and I'm assuming that Demetrio Chavez was driving for Tibet Enterprises, would that be correct?
That's correct, Your Honor.
Okay. What are the possible remedies or the way that that can be handled with the interests of both sides if you're never going to find Demetrio Chavez?
Sure.
I'm assuming that Tabit Enterprises has liability as well. I mean, they have it's a joint liability you're suing on.
Both, Your Honor. So they have stipulated to course and scope. There are also bifurcated claims as to negligent hiring, training, supervision against the company directly that have nothing or someone.
When you say they've stipulated to course and scope, in what kind of official manner? Or is it in a manner that they're going to question that if they end up moving without Demetrio Chavez, or they're locked into a stipulation like that?
Mr. Lopez, correct me if I'm wrong, but they've locked in officially that he was driving in the course and scope of his employment with Ameritrans at the time of the collision.
I will tell you, I'm not sure. I was looking to see if
Okay.
we did a bifurcation.
It's okay. It's okay.
'Cause if we-
I don't need
'cause
to
if
hear
we-
that right now. I'm just saying those are all issues. And if you want to settle them, anything you can settle before the hearing, we can do that. And if you can't settle it, I'll settle it at the hearing. All I'm saying is make sure you got everything filed that you need so that I'm not sitting in court and you're going to look for something. Okay? You already know what he wants. Mr. Jacobson, you file whatever you need to give him notice of that you're going to do, or just write on whatever pleadings you have, but at the risk of not having pled for the motion properly. And Mr. Lopez, any requirements that you have under the code that you have to make a verified response or anything like that, you do that. I'm not going to be on routine, matters like that. I'm not going to be that open to saying, oh, okay, do that. I mean, I do that a lot, but I'm not open to that. If you think
Understood,
that
Judge.
another mediation would help, I have no idea if it would help, except that I know that in cases like these, sometimes different parties are driving the mediation boat, and you can advise whatever other parties you're affiliated with that I'm not inclined to kowtow to you getting either party trying to get any kind of permission or whatever. The lawyers are here to represent whatever the named parties and any insurance companies and all. So I'm not going to be, you bring your representative with you, whoever has one, an insurance representative. I want him in court so that you can make a decision on anything that I rule on. I don't want to be saying, oh, I need to contact this person. So if there is an insurance company, I want a representative there sitting at table with the lawyer that's under that kind of direction. Somebody needs to say something like, okay, we heard and we agree, or Judge, you're wrong and you can't do this, please.
I understand. I don't have an insurance company, but I understand.
Okay.
Judge, I hear what you're saying for the motion that we may be hearing. I don't know that an insurance company representative would be necessary because it's
If I have the
either
power to order him, if I have the power to order that, because y'all, well, okay, let me ask this. I don't normally go into the deposition, but Mr. Jacobson, I'm not putting you under oath, but was it your impression that when you did your mediation, there was an insurance company back there?
I believe there was a either by phone or in person that there was an insurance representative with counsel.
Yeah, so I'm not making an unreasonable demand or requirement that you bring whoever is involved in that, and I'm not going to force that insurance person to say anything. I'm just going to make sure that anything I hear from you, you have authority to say, and that you can make decisive decisions without saying, "Oh, I have to come back and I got to talk to somebody." That's why I want that person there. And if you're uncomfortable about having them sit in the bar with you, put them right behind you. I got plenty of bleachers. So
no, I understand that, Judge. I just don't know.
Wait. You let me finish talking, please. Okay.
Apologize.
You say you understand that. You weren't saying anything that you were ready to do that. So regardless of what you understand, I'm ordering that. Now you tell me whatever you want.
Judge, if you're ordering it, then we'll comply with your order.
Okay. And then of course, if you're talking and if that's anything that you all can use and not put anybody out, you can do that as well. I've hardly ever done this, only because it's pretty extraordinary, because I got to get this case moving. And if the driver is not going to be available, I got to make rulings on to what extent are we going to go without him, if that's what the plaintiff requests. And then I want to make that without you having to worry about what the insurance company might say, because we need to get this going and we have a July deadline. Okay.
Understood, Judge.
Okay. Okay. My biggest suggestion is that you file whatever you need to file to compel whatever you want under the law or within the directives that I've given here today.
Absolutely.
Okay. I'm not writing this down as an order. If it doesn't happen, then I will be issuing orders and writing them, and I'll be making findings. Let me get the court report on this case, please. Rachel, say when. Since I switched computers, give me 1 second to see if they can even hear me. Just a second, please. I'll be right back. Rachel, you got that? No, it's okay. Just announce yourself ready.
I'm ready, Judge. Thank you.
Okay. All right. Calls number 2023 DCV 3314, Derek Jenkins versus Demetrio Chavez Jr. and Tabet Enterprises Inc., DBA Ameritrans. This setting is for a sanctions hearing. This recorded hearing is to memorialize a descriptive of the type of hearing that the court is now requiring in person in El Paso, Texas, in the 168th District Court. So this is a motor vehicle injury. It does involve a truck driver and the trucking company. My understanding is, and it's okay if I'm off on precisely what the status is, but my understanding is that the driver either had been served or presence had been secured, and now the plaintiff is being told, or through his own diligence, that the driver is no longer available, or is not available for the type of discovery that he needs. And this case is set for a jury trial in July. It's not a special setting, but it is a 2023 case. Did I already get announcements?
Not on
We
the
have
record.
announcements of counsel.
Colin Jacobson representing the plaintiff, Derek Jenkins.
Okay.
Your Honor, Aldo Lopez on behalf of the defendants.
Okay. And so this setting that I'm going to have is going to be in person. And I want everything that is pending or that either party believes is pending to have proper filings and proper responses by the setting date. So I'm going to give you at least 8 weeks to get all your filings in. And I've also been told that there's a spoliation issue. So therefore, when something is filed on that, at least I'm going to have notice of that. And so I'm not requiring anything else be filed unless that is required. to be filed in order to bring it up and include it in the lawsuit. And any other agreements that even if there's gentlemen understandings, but you want to assert that in court, for example, with respect to scope of conduct, etc., bring that up to me. And if it's not, if there's not an agreement on it, I'm going to take it as a motion and I will rule on it accordingly. I hope that this is pretty much a good description of the type of hearing so that this is memorialized for my sake when I see y'all in my courtroom. But if either side wants to put anything else on this record, please proceed. Mr. Jacobson, you may first. You may do so first.
It was an accurate representation of what we discussed, and I will reach out to your coordinator to get some dates for in person.
Okay, and then Mr. Lopez.
Thank you, Judge. Yes, it is. There was some earlier discussion about the court we're going to require someone from the insurance company to attend. So I'm gonna note my objection to that requirement.
Okay.
On the record, the insurance company is not a party to the case. And so I believe that's improper. I understand the court's going to order that anyways, but I just need to put that on the record.
Okay, so Mr. Lopez, just thank you for reminding me, because I did want to clarify that on the record. And now that I've heard your objection, I note your objection, and I am ordering this because I believe that I have this discretion, and I know that part of your remedy is to file a mandamus. I'm not worried about either. What I would like is a written objection that either states the law why I shouldn't or states the law why I can't. But I'm operating under the belief that I have the power to do that. And when we discussed it, I noted just from this exchange that there was an insurance company involved in the mediation that was unable to be settled. And when I was also discussing that, my reasoning was that I don't want any excuse for lack of authority by the part of the lawyer just because you got to go check with somebody else. Now you can still say that, but I want a representative from whoever is financing all this, so that I can avoid that. I'm not even going to. You can just tell me he's there in court, but the main thing that I want is authority. So, for example, you can file and say, we object because we have full authority. I'll probably grant it. I won't require you to do that. I've never seen a law firm do that, but go ahead. So I don't want you to accede to it just as a favor to the court or as an accommodation or to not make a bigger issue out of this. I want to make an issue out of it if you have grounds to. Okay? And then I'm going to require that kind of a response. You could still respond just to let me know why you think I shouldn't do it. But if you're going to say that it's an abuse of discretion, I want a little more detail. And I'm ready, I'm ready to go on that. I also, in speaking to the record, I have heard of that happening before. It's not like it's, and I do believe that I have that power. But if I don't, let me know.
Yes, Your Honor.
Okay, so your requirement on that, and this is an order, and you can get it from the, it's in a deposition. I'm not filing with a court, but it's in a deposition. I am making an order in the deposition through orally right here, but it'll be written. I'll give you 2 or 3 weeks to get the record from the court reporter if you want to, and then I'm going to require you to file this within 4 weeks of today. If you're going to file something like that. And even if it's not filing, it's not going to delay our hearing unless your argument is that I can't do that and I'm abusing my discretion. Mr. Jacobson, any objection to that?
No objection, Your Honor. So
Okay.
to be clear, since we have 8 weeks for all the other filings that we talked about, not dealing with the insurance rep, We should be looking at some in-person hearing dates sometime in mid to late March.
No, what's going to happen is Robert is going to send you an email with dates, and then you both pick which
Perfect.
one is mutually convenient.
All right, sounds good.
Okay, so Robert, set it for, of course, on a weekday, but not a Monday or Friday, and set it after. Well, either set it in an afternoon where I'm not going to have any hearings, or if I do have some hearings, set it after. Move those hearings to 1 p.m. and set this at 2:30 p.m. in the afternoon.
Sorry, Judge, I didn't catch a date, or we're gonna get that date with cooperation from both
Yeah.
sides.
You give them like you do in a lot of cases. You give them up
Yes, sir.
choice of dates
Yes, sir.
for Tuesday, Wednesday, or Thursday at 3 p.m. non, let's say,
Yes, sir.
to have this hearing in court, and therefore I have no conflicting hearings. And also, if it can be on a day where I don't even have any hearings at all, I would prefer that because I can also more properly prepare for the upcoming hearing.
Yes, sir.
Okay. Anything else? I'm sorry. That's how I operate, Mr. Jacobson and Mr. Lopez. Is that all right with you?
Totally fine with me, Your Honor.
Yes,
Okay.
Judge.
And if they can't make any of the dates, Robert, however you handle that, you send them more alternate dates, or if you end up calling Robert, that's fine also. All right. Thank you very much.
Thank you, Judge.
Thank
See
you,
you
Your
in
Honor.
El Paso. Hope maybe not, but see you.
No, you will.
Okay. Okay, I have Daddy O's drive-through versus Paseo del Este Municipal Utility District Number 1 and Infomark LLC. Oh, that got canceled. Okay, thank you. Okay. Lawyers that are still here, what I have on the docket are only 2 cases. That's, well, no, I have 4 more cases. Maria Elizabeth et al., United Financial Casualty et al., West Texas Pain Institute et al., and Raiz Federal Credit Union. If anybody here is here and you're like, well, wait a minute, I don't want to sit through here and tell them that I also thought I had a hearing, please speak now or forever hold your peace. All right, thank you. Okay, Maria Elizabeth Burciaga.
Yes, Your
I
Honor.
have
Jason,
Piercy Delaney as a lawyer and Michael or Daniel Hernandez.
Your Honor, this is
Yes.
Jason Medina for the plaintiff. I'm co-counsel with Ms. Piercy. She just entered an appearance.
Okay, so it's Jason
Medina.
Medina, correct?
Yes, Your Honor.
Okay, are you in El Paso?
I'm in Lubbock, Your Honor.
Yeah, I was trying to recognize that background on your window, and it doesn't look like anything in El Paso. No, you look to your left.
Yeah, just a dirty parking lot, Your Honor.
I know. I'm trying to be a little humorous.
Yeah, I gotcha.
Okay, and then Daniel Hernandez, or who's here for him?
Your Honor, Aldo Lopez on behalf of Daniel Hernandez.
Okay,
Good afternoon, Your Honor. This is Fred Hutterer on behalf of Dantex General Contractors.
okay, hold on. So since you're not on the docket, were you brought in?
Your Honor, we're a third-party defendant to this case.
Okay. Give me the name.
Dantex General Contractors?
Okay, I've heard this before, right?
Yes, Your Honor.
It's something about, it's kind of an unusual hazard or something. General contractors. And then,
Yes,
sir, your name? Fred Hunter. Thank you.
Hutterer, Your Honor, yes.
Appreciate it. Okay. Mr. Hutter, since you're so articulate, can you brief me on where we're at on this case? It's scheduled for a scheduling conference.
Yes, Your Honor. As I understand it, Mr. Medina had previously circulated proposed trial dates. I believe he got with Robert, got some proposed dates. He and our office were able to agree on some. I believe that, and I think Mr. Medina can speak more to this, but I believe the reason we're here today is because we never heard back or got any availability from Mr. Hernandez's office.
Your
Okay.
Honor, Jason Medina, that is correct. We were here in November and asked the court to set this for trial. It was continued because Mr. Rincon withdrew from the case. Mr. Hernandez came on. We asked the court for a date. Robert gave us dates, and within the week, we sent numerous dates. Mr. Hutterer was agreeable. We said we'll be agreeable any date if we can just pick one, but haven't gotten any response on a date that Mr. Hernandez would be available. And the dates that we did propose, specifically, he told us he was unavailable. So all I'm asking is for the court to set this for trial. We have a mediation that was court ordered back in November that's coming up at the end of the month. And we will mediate the case with all parties. And then we have a hearing on a motion for summary judgment that Mr. Hutterer filed that will happen after mediation per the court's instructions. And so really all we need, Your Honor, this is a 2022 case and we're just trying to get a trial date and we can't get an agreement from counsel. And so this case will just sit in limbo until we get a date assigned.
Okay, absent any need to discuss how it was characterized about agreements from counsel or whatever, I'm not taking any of that into account, and it's part of having to sit through this stuff. And I don't like to get involved in that kind of suggestion. Mr. Lopez, is there going to be a difficulty trying to get a trial date?
There shouldn't be, Judge. We actually provided dates on November 13th to Mr. Vasquez, Mr. Hutterer, back. So we sent on November 13th. Mr. Vasquez had given us proposed dates. And so we said which ones we were available. We said which ones we might be available because there's a trial that's scheduled already. So I don't know why we weren't able to agree to one when we did provide dates where we said we were available based on the court's schedule.
All right. I don't know if Robert can conference call you guys. And my streamlined method of trying to be efficient on this seldom has any difficulties, but there are 3 parties here. I can have an in-person hearing so I can set the date, or I'm going to ask Mr. Vasquez to send another email. And then if you can't agree, then I'm going to ask him to have an in-person hearing here in El Paso so that I can take up all the details, and then we don't have to do it on a Zoom hearing and let everybody else wait. Is that all right with everyone, or does anybody oppose that or object to it?
Your Honor, I will do whatever the court desires. I think at this point, as soon as we get a date, the case will get moving. And so as soon as we can get that done, if you could give us a time frame for getting an agreement so we can set a hearing. I mean, if we can have
Robert is going to send you an email, and you're going to get whatever time limits he sets out, or whichever one he assumes whenever the lawyers are in a more cooperative mode with each other, because they're able to do that given the circumstances of their case. Unless you want to submit an order, I can have another hearing on an order getting specific dates. Is that right?
We'll look for the email. We'll try to work it out. And if not, we'll send a request for a hearing.
That's fine by us, Your Honor. No objection.
Okay.
That works.
Thank you.
That works, Judge.
Okay, and then after you have proposed dates, and you said you already mediated this?
There was an early mediation, and we are remediating the case per your order, Your Honor, in November. So that's scheduled for the end of this month.
Oh, good. Okay. All right. Well, I thank you. And does anybody else have anything to say before I sign off with you guys?
No,
No,
Your
Your
Honor.
Honor.
Okay. Thank you very much. And you know what? You all have a happy new year. I don't know if I wished everybody that because I had my computer glitches, but I'm still wishing everybody happy new year if I haven't done so yet. Take care, and we'll be in touch, or we'll see you in court. Thank you.
Thank you, Your Honor.
Thank you,
Your Honor.
Judge.
Okay, United Financial Casualty Company versus Ricardo Lomas. I have Rogelio Morales, defense attorney, and Jessica Lobes with an 800 number, presumably for the plaintiff. Is that correct?
Good afternoon, Your Honor. Roy Morales for the defendant.
Okay.
Judge, I'm actually local counsel, Steve Lavoisier as local counsel for plaintiffs also.
Okay, hold on. Stephen
Del Bosque,
name?
Judge.
Wooski?
Del Bosque. It's
Please
typed
spell
up in DELBOSQUE.
Okay. And then, sir, are you in El Paso?
Yes, sir.
Okay. I don't hometown anybody, just interesting to know sometimes. Okay, so it's a scheduling conference. Are there any issues on that, or have you all gone to mediation? Mr. Morales.
Quick
Rogelio
one on that, Your
Morales?
Honor.
Hold on,
Yes.
excuse me 1 second. Excuse me 1 second. Are you a lawyer?
Yes, I'm attorney, Your
Okay.
Honor.
Please
I'm
wear.
in person in the
Excuse me.
depot right now. I apologize for my attire.
Okay, that's what I was going to say. So
Yeah.
since you're aware of that, I'm not going to say anything else.
Okay.
Okay. So what are there any issues on? Have you been to mediation yet?
We have not been to mediation yet, Your Honor. We haven't completed depots in this case, but I think we were ready for a trial date in this case. But I'll let Mr. Bosque share his side of the story.
All right.
From what I was told by counsel, and I guess I was wrong, that they were close to settling this and to ask for 60 days to pass this to try to settle this matter, Judge.
I don't understand. You would know if they're close to. Oh, I see. As opposing counsel, you think there might be some settlement talk?
Yes, that's what I was told by
Okay.
um
Okay.
the attorney
Well, I
hired
mean
me.
that's fine. That's fine. What I can do is give you a mediation date by no later than by no later than May 1, and then we can come back for this, and that'll give you plenty of time to settle it if you're able to do that. Otherwise, I want mediation. And what is this? Tell me what this is. What kind of cause of action this is?
This is a subrogation from UFCC against my client Ricardo Lomas, Your Honor, for a car accident.
Okay. So I used to do this kind of work. There was a car accident, the insurance paid out, and now the insurance company is suing Ricardo Lomas under their subrogation rights. Correct?
Correct, Your Honor.
What's the amount in controversy?
I think it's close to $30,000 if I'm correct.
That's what I saw, Judge. I think 3029.
Okay. All right. A substantial amount for either side. I got it. Who's representing Ricardo Lomas?
I am, Your Honor, Roy Morales for the defendant.
Okay, I don't know if I'm entitled to ask this, but either way, you can say you don't want to answer it. But is there a guarantor or an insurance company behind Ricardo Lomas, or is he standing as an individual?
We were contracted to provide defense for Mr. Lomas.
Okay, all right, thank you. In that case, I'll give you 90 days to see if you can settle it, and if you can't settle it, we'll have the mediation. So in a mediation of something like this, it doesn't involve the insurance company as an actual party. So the mediation would be somebody representing Ricardo Lomas in his individual capacity, and of course, United Financial's got their institutional lawyer for their institution. Am I wrong?
Yes,
Right.
Judge.
So if
Not wrong, Your
I
Honor.
if I set the deadline at that you got to mediate on or before April 30th, would that give you enough time to get us to the next stage if we're going to reach it?
I think so, Judge.
I believe so as well, Your Honor.
Okay, let's do that. You get it mediated before that date, and Robert, you give them a setting for a status hearing or a scheduling conference after May 1.
Yes, sir.
I,
Go.
Hold on. I'm in a different computer. Robert, did you hear me?
Yes, sir. After May 1.
Oh,
Yes,
good.
sir.
Okay. All right. So stay in touch with Robert, or I don't know what he does. He's going to email you right now or whatever. Okay. Thank you.
Judge.
You're
May I be
excused.
excused?
Yes, sir.
thank you, Your
Have a
Honor.
good
Happy New Year.
You too. Thank you very much. Okay, Mr. Foley, you're still on here, or did I fail to excuse you?
No, we're still here. You asked us to stay and see
Oh,
if
thank you.
Mr.
Oh,
Moore
yes.
wanted to talk.
I know. Thank you. All right. Were you able to, is there anything you can represent to me, or should I just move on with what you're requesting?
I think we're just going to have to ask that what's set for today be ruled upon. I don't think we're
Okay.
going to make any
All right.
progress today.
And then, Mr. Amor,
Yes, sir.
you were talking as if, they didn't do this and they didn't do that, but are you asserting a legal impediment for me to move on beyond that? Or were
Well,
you just saying stuff because sometimes people will say, well, they didn't serve me, they didn't do this, they didn't do that.
Well,
Tell me, go ahead.
no, I do feel like I did get an insufficient service of process because I
Okay,
didn't
hold on,
receive
hold on.
any
Let me
notice.
stop you. Let me stop you. You have a right to represent yourself.
Yes, sir.
The requirement is that you have to follow all the rules that the lawyers have to follow also. Okay?
Yes, sir.
So feeling something is not in the jargon of, you know what I mean?
Yes,
Have you
sir.
filed anything, or are you asserting anything legally that you're going to file a motion on? Or can I move on to hear the request for some relief under the garnishment order that I signed?
Well, I did file for the properties of protection, but again, the only reason that I'm here today, sir, is because I was following up on that paperwork and I went to the
Okay.
library. I went to the library on the 12th floor of the El Paso courthouse. And when I signed in there, I noticed that I had a court hearing this week. I went Monday or Tuesday of this week, and that's when I found out I actually had a court hearing, which I had no recollection of.
It was written in the library, or you came across a paper
No,
in your
because I
file?
went into the public records
Oh,
because I did the e-filing for the properties protection. But that was the only reason why I knew to be here today. Or I reached out to Robert yesterday and he told me that I had a hearing today.
right.
That
And so, I mean, all I want to tell you is that's great that you're here because you're supposed to be here. And then even if you didn't have, if there was some reason why you didn't have enough notice, you showed up, you're here. So all of that is water under the bridge.
But for
Okay?
what I'm saying is for the past ones, I have again, I have no recollection of any court hearings because I never got served. There is a document that says there that I signed
Okay.
for a
Let me do
certified
this.
letter.
I know what you're saying. Okay. They have their garnishment order. You haven't filed anything to oppose that. However, you are pro se, and garnishment is an extraordinary relief. And you're asking me and making questions that that I think require me to instruct you, which is all I can do. I can't take your side or operate for you. But also, when you're sued, and you're sued here in El Paso, I'm going to have a hearing here in person in my court, so that I can hear everything that you're saying, and I can rule on it, or we can continue to move forward towards the relief that I signed off on with a garnishment order. You understand what I'm saying?
Yes, sir.
Okay. Rachel,
Your Honor,
can
if
I make her? Pardon?
Your Honor,
Yes.
this is Bert Martinelli on behalf of the bank. We're
Yes.
talking about $922 that have been garnished from Mr. Moore's account by the bank. Pursuant to the garnishment statute, regardless of what Mr. Moore claims or doesn't claim with regard to service, it doesn't look like the service issues relate to the actual garnishment, because the garnishment is actually just an action between the creditor and the bank Mr. Moore, obviously is here today, hasn't filed anything to challenge the garnishment. I think at this point, in order to minimize exposure to the creditor's attorney and maximize recovery, and limit any other further exposure to Mr. Moore, our position would be that, one, either the order be entered on the garnishment, because that's all it is. It's, hey, when the bank was served, did you have money in the account? Yes, we had $922. Has anything been filed to challenge that? No. And so we should be discharged on our answer, and pursuant to the garnishment rules, would be entitled to fees for having to appear and answer, like Mr. Valley stated earlier in today's hearing. I think if this really drags on any longer, it's really not worth the $922 in account. So
Why is that you're asking me to be pragmatic, but why is it my problem? You're the one that filed the garnishment in my court and
No,
under a judicial. Wait, listen to me. I'm talking. I'm talking. Let me finish and then you can talk. Okay?
Okay.
You filed it in my court. I have jurisdiction over it, and I've listened to your pragmatic suggestions. But why is the amount my problem? I mean, why? It could be $5 million. Yeah, I'm telling you what Mr. Amor is sitting there saying. Hey, I don't have that. I bet I don't have that much money, and he's saying, oh, because he doesn't have that much money. Why don't you just do this? So hold on one second. I'm going to let you respond. We're not on the record, but I'm going to let you respond. Robert, bring me a copy of the garnishment order, please.
Yes, sir, Judge.
Okay, I'm going to take a little break, and I'll be right back.
Lawrence, has he filed a protected property claim form at all on this?
He did, but it's not relevant. But,
Yeah.
do we want to have a hearing on it? Every other judge in the state would look at it and grant the order, but we don't have that judge. We have this judge.
No. Mr. Moore, are you there?
Yes, sir.
Do you have an email address? What's your email address?
You sound like you're underwater, but
Do you have an email address?
yeah, yes, sir. Of course I do. Even Mr. Foley has that. It is AMOR, J as in January, S as in September, O as in October, N as in November, 915 at gmail.com.
Perfect. Thank you.
You're welcome.
Can you hear me?
Yes,
Yes,
sir.
sir.
Oh, good. Thank you. Okay. So I'm looking at the paperwork that got filed in November of 2025. I show a default judgment. It doesn't say anything about garnishment, or if it does, please point that out to me. And then there's an Exhibit B, and there is a motion for judgment in garnishment action, but I don't see an order that I filed. Can you direct me to that, or show me, or email it to me? Well, let me ask you, you all are familiar with the forms you use.
Yes, sir.
Okay. What is it that I signed or whatever that makes you think I gave you a garnishment order?
You gave us a writ of garnishment, which we
Where-
had served upon the bank.
Okay, I gave you a writ.
Yes, sir.
Let me ask you some, because it's not, well, Robert, is there a writ of garnishment on file? There is? Okay, let me see it. Okay. Mr. Martinelli, what's your involvement in this?
I just represent Wells Fargo, the bank, Your Honor. So when they're served with the writ of garnishment, they've got to obviously file an answer and either one, try and get a non-suit if there's no money in the account, or file an answer if there is money in the account. And that's the only way I get paid, is if there's money in the account.
Okay, so I know you all do a lot of paper filing. You filed a motion for judgment in a garnishment action.
Yes, or the plaintiff did, Your Honor.
That's my motion, Your Honor. That's correct.
Right. So then, does that mean that the indebtedness was owed and then you got besides a judgment on the debt, you got a judgment on a garnishment action?
Be a, oh, I'm sorry, Lawrence.
No, no,
Your
I
Honor,
mean,
you're absolutely correct. There's the underlying judgment between my client and Mr. Amor, and this court granted judgment against Mr. Amor. And then when the writ of garnishment issued to the bank has to freeze the funds down until Your
wait a
Honor.
minute, Mr. Foley, wait, I understand that. I understand that. I'm getting to the authority for you to do that, okay? So there's a default judgment with my signature. Then there's a filing with the district clerk, and the way that we, it's not set up so that our courts do that. They set it up so that you can submit it to the district clerk, and the district clerk will issue whatever they need to issue. But they're not going to file anything that you file without a signature. But I'm trying to figure out how this got filed, that there was an order for a writ of garnishment. I don't see that. You even say that I gave you that writ. You filed a motion for it, but I don't see that I gave you that I signed an order on the motion.
That's correct,
well,
Your
let
Honor.
me just say, hold on,
order.
sir, listen to me and let me talk, okay? And I'm sorry for being adamant like that, but I'm never going to get anywhere. I know, but this is a judgment. I know that it's their motion, but there's not an order for what pay. I have an assistant here. Show me some paperwork. So give me a chance, please. So I have your motion for judgment in a garnishment action that got filed in November, some months after I granted the default judgment. Is that correct?
That is correct, sir.
Okay. So then the motion for judgment has an exhibit, and the exhibit has a copy of the default judgment, signed May 15th, 2024, but that got filed November 7th, 2025.
Yes, sir.
And now I'm trying to, okay. So this writ of garnishment, let me look at this. There was a writ of garnishment filed July 30th without my signature. And what I don't understand is why the district clerk sealed it as if I had granted a writ of garnishment. If you can look at your file and let me know.
I'm looking at it, Your Honor. I see that. And
Okay. No, right. Just please listen to me, okay? Here in El Paso, I don't know. Remind me again where you're at.
Austin, sir.
Okay, so here in El Paso, we said the district clerk had the county set up a system, and the parameters for them is if you want anything signed, we're not going to sign it unless it has an order. So a lot of times when I have these hearings, and then somebody says, we already filed the default judgment. I used to do collections work out of Austin when I got out of law school. You could file it to the district clerk, and they would handle all that paper shuffling. And they would, they would take it to the judge would sign it, and then the district clerk would pick it up and they'd prepare stuff. Our district clerks set it up so that they only do the minimal. In fact, locally, my opinion was, we're doing all the work and all that stuff. Fine. So you can file a motion and they will accept the motion and file it. But if they get an order without a signature, they're not going to file it. So a lot of out-of-town lawyers sometimes send it to the district clerk, and I don't even know what kind of letter they send you saying we're not going to file this, or maybe they don't respond. What's unusual here, though, is that they filed it. They filed whatever you submitted, and they certified it. But they didn't certify a signed garnishment, is what I'm thinking. So, Mr. Foley, I've been a little short with you, but please explain if you disagree with that or if I'm missing anything.
No, Your Honor, I believe you've said it correctly. We applied for writ of garnishment. Darlene Duran, deputy of Norma Favela, the district clerk, issued the writ of garnishment. and we had it served on the bank. You're correct. That's what happened, and I do not have an order from you that says that.
Okay, what, am I wrong, or the district clerk can issue a garnishment, or would it would require my order?
I have not needed a judge to sign a writ of garnishment when it goes out. The judge signs the order ordering where the money goes, whether it's returned to a defendant like Mr. Amor or turned over to my client or turned over to the bank. In my experience, the judge does not sign the writ. The deputy clerk issues it, and we have it served on the bank by the constable.
Okay, I can go get my. So somebody want to see? Yes, sir. Go ahead, Mr. Martinelli.
Your Honor, if I may, Mr. Fowley is correct. The only time that I will see an order from the judge issuing a writ of garnishment is if it's extraordinary relief by way of a pre-judgment garnishment, not a post-judgment garnishment, which is not extraordinary relief. That's just standard relief for collection on judgment.
Okay, and I can stand to be corrected, but let me just give you an example. I'm trying to figure this out.
Sure.
I told you I used to do collections work. So Toyota Control Corporation. I don't know if they've ever been clients of yours or whatever, but out of Pennsylvania or wherever they're at, they would file orders for receivership, post-judgment receivership. You can have so many extraordinary powers. They would just submit it. And even some of my colleagues, I would say, are you getting these? And when I read it, and I even called one of our local experts, I'm saying, I'm not going to let the receiver carte blanche go to the bank. And that's what the order said. But we had to sign it.
Yep.
So a writ of garnishment is something that you're entitled to for collection purposes without having to get the approval of the judge. Is that correct?
Correct.
Okay. I'm better oriented now. So a writ of garnishment that is issued that you're entitled to as a collector, as a creditor, judgment creditor, you just apply for it. Who checks? And you on your order, you cite all the legal stuff. And I just want to also say, this doesn't have anything to do with the circumstances here, except sometimes I find that creditors or lawyers from out of town aren't familiar with the type of defendants that we have here and the high incidence of poverty population here in Austin. And so whenever stuff like this is filed, including like pro se representation, there's nothing in the code that says how much attention I need to give it to, but I bring in the parties and in front of the other side, and I explain to them what I've been explaining to Mr. Moore. But that's for pro se representation in the lawsuit. Okay, so Mr. Foley, please confirm to me, now that I'm better educated, that everything seems in order for you to have gotten rid of garnishment based on an amount that is owed in a default judgment.
Yes, that is correct, Your Honor. I agree with the statement you made.
Okay.
And Your Honor, from the bank's perspective, we're not going to freeze an account unless the creditor has provided sufficient documentation to the bank to show that the writ of garnishment was appropriately obtained, because we know in certain circumstances, having accounts frozen or amounts taken from an account or could be detrimental to the account holder.
I know, Mr. Martinelli, but let me just suggest something, okay, with all due respect. All right?
Yes.
Because I appreciate being educated and talking to you. The rationale that, why are we doing all this if all he's got is this much in there? To me, just given, why would he be treated more harshly and not have the benefit of having a face-to-face just because he's poor or because he only had a certain amount? That's all I'm saying.
I think maybe we were talking past one another. The only reason I would say I understand $920 is a lot of money for individuals, like anyone, a lot of people. But the only reason I said that was not to minimize the impact or potential impact on Mr. Moore, but was really the fact of, hey, if you require an in-person hearing or, travel expenses or things like that, those fees and expenses are then taxed against the plaintiff in excess of the amount of money that's held in the account. And so that's why, not minimizing behavior, it's only $900, because if we go through and do everything in person or travel expenses, that's what we try to get these resolved on the front end, is that now the plaintiff is looking at having to pay additional fees on top of not being able to recover anything under the judgment to the garnishee bank for having to appear and answer. So that's the only reason why I was saying that, not to minimize, hey, there's only that much money in the account.
No, I understand the sincerity and your perspective. Okay. So I'm just trying to get straight. Only hopefully you've educated me, and I hope maybe I can educate you if you need to be educated. If not, you have your right to know. But let me ask you, besides being a banker, are you a lawyer?
No, I am a lawyer, Your Honor.
Oh, okay. You're the lawyer for the bank.
Yes.
Okay. So what I'm saying is, you yourself have gone through extraordinary legal procedures. Well, first of all, before COVID, we didn't have these hearings. They were all live. Okay. And I don't know if you heard me tell another party, or maybe I told you all, that there was a time when there appeared to be more and more lawyers from out of town filing in El Paso. And PI lawyers here, for example, would say, oh, they're coming in here and they're taking all our business, yada, yada, yada. And then also, though, I was aware that there were a lot of big law firms providing legal services all over Texas, probably because they were undercutting rates because they could, or here in El Paso, they could charge less because there wasn't so much overhead as if you were a law firm in a high rise in Houston or whatever. So at a certain point in time in my very young judicial career, I told myself, I need to remain neutral about anything that anybody tells me, these lawyers that I run into, regarding, any party's right to hire a Texas law firm. We used to call it hometowning. Have you been around long enough to hear that term?
Yeah, I've been practicing for 25 years. So yes.
Oh, no, okay. Oh, well, I was a prosecutor for 20. But the hometowning, meaning that the local lawyers would get a little bit of a wink advantage because of the local judge that they may have contributed to, or they're in the community or whatever. In my mind, I have to actually say that and assure out-of-town lawyers, because that doesn't exist with me, particularly once we started doing Zoom. We never did Zoom here until COVID. And then I thought that was going to be a temporary event. And when COVID passed, the Supreme Court didn't lift and encourage, in some cases, to continue doing Zoom because it is very convenient. I wanted to hear them in court. But my staff came and said, the lawyers would, even though they're 2 blocks away from here, they don't, and I don't know what their time slip looked like, but they liked having Zoom instead of having to come down to the courthouse and be very professional. And so I don't see them very much around here anymore. Okay. So what you're saying about the utility of efficiency in a proceeding where Mr. Armour could care less whether efficiency was used or not, he just wants his due process. I haven't heard out-of-town lawyers, or even in town, trying to say that in a case like this. Because what you're trying to do is be efficient for the whole system, even, but what, at the cost of Mr. Armour? And it just sounds a little bit too exclusive, in my opinion. But that's just me. It's not going to affect how I rule, except that you're asking me, why don't we just do this? Because he only has that much. And what I'm saying is, you went through all these proceedings to bring it in front of me in court. No, let's have him in court so I can look him in the eye, and then you or Mr. Fowley can tell me in person to answer all these questions that I have. because I'm not a collections court, and I have a lot of questions, and I've been around long enough to I don't even think it's humility to not have the attitude that I know everything and I don't need to be educated. So, however, I may look to all of YouTube that's looking at this and all, when I tell somebody, can you please explain to me what that means? And it might be something very simple that the whole world understands except me. Well, I'm the judge and I don't have that hesitation. So I can tell you that a lot of the civil cases that I've handled have been default judgments on debts. And then I never have had one. I've told you about the receiverships. I've had those submitted afterwards. So it would be a motion for a receivership. And then when I started reading the terms, I'm like, man, some receiver is making a lot of money on, even if they're just charging, a fee by the order. Because all they have to do, because they know how to do it, is have the forms and send them to the bank and say, here's a receivership, I have authority. And then, for example, someone like Mr. Moore, he's got his bank account, and all of a sudden in the receivership, the receiver not only can find it, he can take it. In this garnishment, explain how it came to me for this hearing.
Explain how.
Explain why I'm having a hearing on this garnishment.
The garnishment statute requires that any garnishment be set before the judge who granted the underlying judgment. And since you signed the underlying judgment that we were just discussing, that's why this garnishment was assigned to your court.
Okay, and so because I signed that, you're not coming before me with the fact that you have a garnishment writ. You're coming before me because you recovered funds, and that's why it's being brought to me, or you identified funds.
Correct. The bank is holding funds, and we would like a ruling as to whether the funds go partially to my client, partially to the bank, partially to Mr. Amor, the three parties, and we're asking you to decide because obviously, the three
Why would
parties.
any go to, for an amount like that? Why would anything go to Mr. Amor under the priority of the distribution? Why would
Well,
any go to him?
In this case, I would say he doesn't deserve any, but as you were saying, he's entitled to his due process. So if he has an opinion, he certainly can present it. And maybe he knows something I don't. I'm just saying he's not precluded from presenting his case.
Right. Okay. So, Mr. Foley, I just wanted you are very articulate and direct on the answers that I'm looking for. Okay. So when I was cutting you off, a lot of it has to do with I want to complete what I'm asking because I don't want to engage in a tete-a-tete with you to get to what I need to know. And so if I was brusque, I'm not going to apologize because I can do that, but I am aware that I did that. And if it was offensive to you, then I don't believe that I overstepped.
I do not believe you did, Your Honor. And I'm sorry if I made a facial expression that showed that.
No.
I can tell you I've had authority figures in my life who are always strict, and that's because they follow rules. And I believe you're following the rules. I'm not upset.
I appreciate that.
Offended. Okay,
thank you, and I appreciate that. So now that this amount has been collected, and you have to bring it in front of me, and what am I going to end up? You attached a spreadsheet, or maybe the bank did for you, but there's you're following all the procedures, and you're the lawyer in this proceeding. So there's a spreadsheet, a payment and payoff calculator. So you got the date of the default, which is why I issued the judgment. You have the date of the judgment. You have the principal amount, the pre-judgment rate, the post-judgment rate, the attorney's fees, and the court costs. So if those need to be distributed accordingly from whatever got recovered, I understand that. And then you have your interest, which you're entitled to, and that's there. So now that you have Mr. Amor here, he showed up to your hearing, and then somebody on your side mentioned due process, and meaning that whether he knows he was exercising his due process or not, he has it. Excuse my gum chewing. Doctor's orders. I gotta exercise my masticators, whatever you call them. So if he's complaining without any written response via Zoom, telling me what he thinks he did and what kind of rights he had. And so if I were to say, fine, I'm overruling anything you say, what would happen next with this money that you have? Like this particular attachment doesn't show, it's a calculator in a schedule of what you already got, but where is anything explaining how much you recovered from Mr. Amor? And I might not have gotten to it yet, okay? But where is that? Oh, here it is. Wells Fargo original answer to writ of garnishment and request for award costs. Okay, I got that. Let me look at it. So Wells Fargo got notice as a party, and Mr. Foley, you're not the lawyer then for Wells Fargo. You're just a lawyer. Maybe they paid you or they sent you the case, but you're the lawyer asserting the garnishment. And
On
then,
behalf of Daimler, that's correct, Your Honor.
yeah, on behalf of whom?
Daimler Truck Financial is my client, the creditor.
Right, the creditor, the judgment creditor. And so now Wells Fargo finds out that you garnished, and so they filed an answer to your request saying, hey, this is the amount we're owed. Would that be correct?
It's the amount that was trapped in the account at the time of service, Your Honor.
Right, the amount that you have a right to claim.
Well, not to claim, but for the plaintiff. That's the amount that we're holding in the account pursuant to the writ. The bank
I'm sorry.
is only.
You're the bank holding it. Okay, I got it
Yes.
now. Okay. And so these are the account numbers that you took out a total of $900 and some dollars.
That's correct, Your Honor.
So now the you just need my signature to set, because you're holding it almost like a trustee or a middle
That's
person.
correct.
And then you're just saying, we're holding this money, Judge. It's not our job to do that, but in a garnishment, we have to do this. So who do we give it to? Take it off our hands. Yes.
We're looking for an order from the court ordering us to, one, pay the funds to the plaintiff, and then to cover our request for attorney's fees, Your Honor.
Okay, so in addition to being the bank holding it, you're entitled to attorney's fees because this is
By
a judicial
statute,
proceeding.
By statute,
So-
Your Honor.
So what attorney's fees are you requesting?
$750, Your Honor.
Okay. So, yeah, I see it here. As a result of the service of the writ, it's been necessary to employ you as their lawyer to represent it, to recover, and submits that a sum of at least $750 would be a reasonable attorney's fee. And then your hourly rate. Okay. So the 800, so the entire amount, well, that's a source account. Okay. So then once it gets turned over, who am I supposed to say who is going to get distributed that amount?
Yes, Your Honor. I think in the proposed judgment that Mr. Foley, I think, is submitted, it should include some order language in there that says of the funds held, $172 will go to the plaintiff and $750 will go to the bank's attorney.
Okay.
It's a flat
I'm sorry, what?
It's a flat fee.
No, I understand. I mean, whatever you're entitled to collect, whether you want to make it a flat fee or not, or it's a statutory flat fee.
It's not statutory, but I typically do flat fee, and so it kind of dovetails back to what we talked about it being a small amount of money that after a while, the $750 flat fee starts eating up and starts reducing itself to $10. I'm effectively working for $10 an hour or something like that, but
Okay, I got it. No, I mean, you do volume. I mean, I used to do collect. Well, however you bill, that's great. I was just a lackey in the firm I was in. Okay, so you got that amount. Now you're filing your claim for it. How did Mr. Moore find out that his, other than going to the bank and not having his money available, how was he officially notified? You were notified because you're the lawyer for the bank that had it.
They were served, the bank was actually served with the constable. The registered agent of the bank was served by the constable pursuant to the statute. Let me try that again.
No, the bank was served, but what I'm saying is you were already
That's on the
served,
bank.
so you had the garnishment in your.
Yes,
Yeah. And how did they notice in it that he had money in your bank, or who searches to see where his money is?
the bank has a writs and levies department. So when they are served with a writ of garnishment, they will perform research to, one, confirm the existence of an account by name, social security number, account information, or other personal identifying information. And based upon the results of that search, well, then tell me, counsel, and relay appropriate business records to me indicating the results of their searches. And then I will use that to prepare the answer or seek dismissals from the judgment creditor as necessary.
Okay, so the judgment creditor, how did they know to send it to your bank? Or did they send it to all the banks? How does that work? Do you know?
They either one past history, or they use asset searches, or I've seen some creditors serve 10 banks at one time, hoping to get lucky on one account. And sometimes that happens, sometimes it doesn't. I don't know exactly why. We're one of the bigger banks in Texas, and so they'll serve the Bank of Americas, Comerica's, Wells Fargo, Plains. Those are all pretty much hit quite a bit because those are the ones that have most of the customer base. But then you're asking about Mr. Moore being notified of the garnishment. One, he's going to be notified when he goes onto his account and sees that the funds are frozen. But then there are also statutory requirements that the creditor has to undertake in order to comply with the statute post garnishment.
But what are the protections of the judgment debtor?
May I address that, Your Honor?
Yes, sir, you may, sir.
I'll let Mr. Fowley respond to that because that's under his purview.
So that's a great question, Your Honor. The statute requires that a creditor, when they have the writ of garnishment served upon the bank, after the bank is served, we must send notice to the last known address of the judgment debtor. In this case, the judgment debtor, as you know, is Joseph Amor. On September 23rd, 2025, we sent via regular mail and certified mail the statute number is 663A. We sent the statutory notice for 663A, a copy of the writ of garnishment, the instructions that come with the writ of garnishment to instruct a debtor how to handle a garnishment, and the notice of the protected property rights, which are required to be sent by statute, and the protected property right claim form that I believe Mr. Amor addressed earlier. Shortly after we mailed that on September 23rd, 2025, we received the signed green card back that appears to be signed by Joseph Amor on 9/27. So that's when we believe we properly served him. Then we shared a copy.
Go ahead. Go ahead.
And then we shared a copy of that letter and the green card with the bank, because as Mr. Martinelli said, they are not supposed to hold funds if the creditor is not following the rules. So we showed them to the bank to confirm for the bank that we were following the rules. And you'll see that letter as Exhibit B in my motion. That's how the defendant gets notice and a chance to appear here before you, Your Honor.
Okay, so for every single, I'm sorry, somebody want to talk?
Me, yes, sir.
Okay, Mr. Moore.
Yeah, I just have something to say to Mr. Foley or to everybody.
No, I don't want you to do that right now. I don't want you to do, sir.
Oh, I'm sorry.
Sir, listen. Okay, I'm going to give you a chance to do that. If it's something you want to say to him, I don't want to do that right now because I'm still trying to determine some things. You can listen in on that because it involves you. but you will have a chance to say whatever you want. And I would suggest you go get a pen and write down and keep any questions you want to do. Okay? All right. So, Mr. Foley, for every bank that you send a garnishment inquiry or that you send it to, you send a notice to Mr. Moore without knowing that he has money there?
That's correct, Your Honor. As soon as we get the report that the constable has served the bank, we send that notice. And I want to address the earlier question you had. How do creditors find these banks? And Mr. Martinelli suggested that some creditors' attorneys may send them willy-nilly, send them to every big bank. Our firm doesn't do that. Personally, I don't think that's fair. I think it wastes the bank's time and the court's time. We have a good reason to believe why a judgment debtor uses a given bank when we request it. In this case, we specifically only asked for Wells Fargo. We didn't ask for any other banks because we were able to determine through a previous cashier's check that the defendant had paid to a creditor. That cashier's check was created on a draft from Wells Fargo, which led us to believe that he was a customer of Wells Fargo.
Okay. That makes a lot of sense, and that explains. So, I mean, there's no unfairness involved in you being able to investigate records that you have, particularly if they might be related to this. I got that. All right. So, Mr. Amor, what is it you wanted to say, or I don't want you to ask the lawyer.
Yes.
You have to ask your questions through me.
Yes,
So
sir.
tell me what. Go ahead.
Oh, yes, sir. All I was gonna say was the only way I found out that I was garnished was at the grocery store when my card was declined. And then I made a phone call to Mr. Foley. And then soon after that, he then sent me the papers for the protection of property after we spoke on the phone. Not prior.
When you say
or-
protection of property, are you talking to this standard form that they put in that you can use as a worksheet on their Exhibit B, or what are you talking about?
It's what Mr. Foley was stating right now, that he just said that he sent me with the statement of my writ of garnishment, which I didn't receive till after. It's called protected property claim form.
Oh, okay. I understand. I think I understand that now. What kind of property do you have that's exempt? Is probably what he's asking for.
Well, yeah, and he was trying to tell me that I could apply or send in the paperwork to get the writ of garnishment expunged, or so I could get my money back, and then find out another way to come to an agreement on what he's suing me for.
Okay, I don't see anything wrong with what you said. As far as I can try and figure out, I think I know why he would have done that. I don't think there was anything wrong for him to do that. Making some assumptions, but is there anything else that you wanted to tell me?
Just again, like he keeps saying that I was served, but I was not properly served with any information. That's why I have been missing out on these hearings, because I have no recollection of them. I have no paperwork. I have false documents saying that my initials were signed on a certified letter.
Okay, and you didn't sign anything on a certified letter?
Sir, the mailing address that I have belongs to my 79-year-old father, which is of a sound mind, and
I know,
he is here every day.
okay, but Miss Amor,
Yes, sir.
The way the post office works, you can't pick up the letter unless somebody with an ID picks it up. And if you saw initials, the post office doesn't say you have to sign your full name. They just want an indication that somebody picked it. Well, you're nodding your head. Explain to me, so I'll shut up and listen to you. Go ahead.
What I'm saying is that on the last one that Mr. Feldy sent me with a property protection of property form, I was here at the address and the postman walked up to me with the letter, which I did sign for. And that one I am accountable for because I did sign for it, because I was waiting for it to try to get my money back.
Trying to get what money back? What money are you talking about?
The ones that they
This money right here?
Yeah.
Okay, so after they got the money, it's when he's undergoing these other procedures. Okay, I understand that. In other words, something where you think you may have been treated unfairly or they're lying? I haven't seen that from the kind of paperwork that they file and the the precautions that they take to show that they're not doing anything underhand. Number one, and number two, they don't have a motive for that, to abuse that protection. Like, anything is possible, but I understand your suspicions and all, and then if there's a way to prove that, I can find out. But I don't think that has anything, that is not connected to the question in front of me about your money that got garnished.
Well, I guess I'm just.
And then wait, Mr. Ron, let me tell you how it may not be unfair, but I can't operate with you. It's not a small claims court. You got to put everything in writing. Then they're gonna look up case law and argue why you're wrong and all. And you haven't done that, and I can't give you a shortcut for that except to hear the level of naivete you might have to assess that on how I want to handle this fairly, not only respecting your rights, but respecting their rights. Do you understand what I'm saying?
Understood.
Okay. So I just want to continue if I didn't forget what I wanted to say. So once, Mr. Polly, you now have this small amount compared to the judgment.
Yes, sir.
And you didn't know if he was going to have a small bank account or a big bank account.
That's correct. I did not know.
So once you have it, you're trying to maximize your profits or your recoveries for your clients. And Mr. Martinelli doesn't seem to me that he has standing to come in and say, well, gosh, to tell your client, because we only collected this much, it's not worth it for us to do all this other stuff we do. That is something that exists because that's the way the system works. But Mr. Amor is not responsible for that dilemma. Is that correct?
I agree. I agree. He's not responsible for that dilemma. And Your Honor, I will tell you that for $100 and some, to be honest, if it would not cost my client money, I would have just dropped the matter, let the $100 go back. But here's the issue. If I were to non-suit this garnishment, Mr. Martinelli would have every right, and the law of statutes behind him, to come after my client to pay that $750. So I have to bring it before you to protect my client from having to pay Mr. Martinelli's fee when Mr. Martinelli could take it from Mr. Amor's account. So that's kind of why we have a small case here before you, because everyone wants to make sure they're all protected from not having to pay the $700.
Okay, but all right, I can understand that. Your rate, if you were in court, it's probably you've already exceeded the $750. However, your payment is. But would it also not be true that if you dismiss the garnish, are you saying you're going to dismiss this proceeding and the whole writ, or you can just selectively not pursue one and you pursue another one?
No, I was speaking hypothetically. I can't dismiss it, and I was not intending to dismiss it. I was just explaining why I brought a case before you where I'm seeking $100. That's why.
I understand.
Okay,
I know
I'm
that.
sorry.
Okay, I know. I understand that. So my next question is, but you're still going to be owed 40,000 or
Yes,
43,000. Okay. So we are just talking about a process. Different people have different types of discretion besides a judge. Actually, I shouldn't have discretion. I should just be, black and white. To exercise whatever you want to do to selectively not pursue it or pursue it without a hearing. Let's say that you wanted to bring Mr. Amor in just so that he understands you have that power and he's in front of me. And then, maybe he'll be more likely to come up with the money if you think that he's got it. There's all sorts of stuff involved in that. So for this particular hearing, asserting what you want to say, and then me, I may change my mind about the in-person requirement. Okay, now that I understand the process better, and you've answered some of my questions. But Mr. Moore could say that. Judge, you're not answering my questions, and you told me you're not going to hold it against me. I want a hearing. And then you'd have to do that, and then you'd have to make that decision, or you'd have to do whatever you're going to do. But would I be wrong in stating what the power, what's involved here as far as the judicial power?
Yes, Your Honor, I believe you can set a hearing for anything. I was under the impression that today, this Zoom meeting was the hearing for this. But of course, you could continue it. You could ask for other evidence. I agree with you. You have that power.
Okay, but it is. It is that. This hearing is that. But just because it's Zoom doesn't mean that I drop my standards. And it doesn't mean that I automatically, insist, okay, I got to make a decision on Zoom. I had 7 people. Did I set another one for an in-person hearing? I do that at my discretion, because not just because I can, it's because I'm trying to get down to be fair to everybody, to what's going on. I managed to do that right now, and I really appreciate your patience on that. When I realized that I didn't understand the procedure. So you're asking me to sign approval, or the bank is asking me to sign off so that they can take the money out of their hands, and then who do they send it to, right? That's what's being asked.
Yes, sir.
And the case would be concluded at that point, Your Honor.
Mr. Martell, yeah, I'm sorry, say it again.
And the case would be concluded at that point, Your Honor. The garnishment action would be.
No, well, yes, but you're talking like it's, yeah, Judge, come on. It's easy, just do that.
If I'm coming across that way, I apologize. But I think that for the purposes of the hearing today, I think both plaintiff and we're in agreement with the motion, is that we're looking for a court order that allows my client's only going to pay out money with a court order. And so if the plaintiff would like the $172 and also pay for my appearance fee, my client requires a judge's signature on an order to make that happen. Or an agreement with Mr. Moore that happens, or a Rule 11 agreement or some other way, but absent Mr. Moore's agreement, we have to have the set for hearing, and the court has to order how the monies are to be distributed.
Okay, let me try and do something in the proceeding, okay? I'm not on the record, but if anybody wants me to be on the record, I can. So now I'm in the proceeding, and Mr. Moore has made an appearance, and he's here, okay? Mr. Moore.
Yes, sir.
You have a lot of options because you're a party to this hearing. You could insist that you have an in-person hearing because you can better represent yourself, or for whatever reason you want, or you can agree and say, yes, Judge, go ahead and give them my money that they garnished, and therefore, and that they're entitled to garnish, and then let me go home and eat dinner. What do you want?
Yeah, let's do that. I think we've all had a long court hearing. I mean, it doesn't do
That's
anything for
perfect.
me anymore. It's already I'm in a hardship already. So you guys eat steak, I'll eat ramen.
Okay, so you're in agreement with what the relief they want.
Yeah, I mean, what can I do, Judge? I mean, I didn't get.
Okay, I can't explain to you. Listen,
I
Mr.
understand.
Moore.
I
Yeah,
understand.
I told you it's your choice, so don't ask me what you can do. You just told me go ahead and give my money to them.
Yes, go
That's
ahead.
fine. Okay, submit your paperwork.
Yes, sir.
And if you already did, let me explain, Mr. Foley. I don't know if you've been dealt in El Paso County a lot. For me, you're going to get a quicker result from that paperwork, and please send a copy to Mr. Moore on the submission, not on the end result. Do you have an email, Mr. Moore?
Yes, sir. Mr. Foley
Okay,
has
so
it.
give it to Mr. Well, hold on. Don't say it here because I don't want anybody saying no, or they're going to contact you that's watching. So you can get it from, you can give your email to Mr. Foley directly if you call him, or Robert is going to have it there so he can have an email to send you the paperwork that's filed. Okay? So Mr. Foley, send me the paperwork that I need to sign. And if it's already, if you might have sent it before, the best thing to do is send it to Robert, and I will sign it, and he's listening to me, And then it'll get filed then, because the clerk is not going to file anything unless it has my signature. Are you waiting for a response? Are you looking at a terminal? Where are you? Mr. Foley?
I'm
He's
sorry,
on mute.
I was
Yeah.
on mute, Your Honor. Yes, I understood what you said. Send a proposed order, copy Mr. Amor, send it to Robert, and that the clerk will not send it to you until it's been signed. So I'll send it to you, and obviously I'll copy Mr. Martinelli as he's a party as well.
And you have his email?
I have
Yes.
both emails, sir.
Oh, good. Okay. All right. So that's taken care of to my satisfaction. It's going to get signed and entered. And then, Mr. Moore, you're not through with this whole procedure because they have a writ of garnishment, but that's how you handle this one. Okay?
I understand. Yes, sir.
And then I take it, Mr. Foley, that your proposed order is also going to distribute whatever the bank is due out of those proceeds.
Yes, Your Honor.
Okay. I want to be very sincere in thanking you for educating me like this. I now understand this a lot better. These are not common. I don't know how often you have hearings on this, but I'm not a specialized court where it routinely receives this and signs it. And I now know a little bit more than I knew before this hearing. And then, Mr. Moore, thank you for your presence, and then the next time, if you don't appear, your absence is going to be treated the way the law would require me to treat it. Okay.
Sir. Yes, sir.
Thank you,
Okay.
Your Honor.
If you see me at Albertsons or anywhere like that, you're not going to get mad at me.
Of course not.
I know that. I'm joking.
Why do you care? You're retiring, Your Honor.
Yeah. Thank you very much, all of you. Have a
Thank
good
you, Your
afternoon.
Honor. Excused. Bye-bye.
Bye-bye. Oh, did I have anybody left? Oh, Mr. Escobar. Sir, Mr. Moore, you're excused, huh?
Yes, sir.
Who
Yes,
did
Your
I have
Honor.
left?
Good morning, Your Honor.
Good afternoon, Your Honor.
Good
Ansel Escobar for West Texas Pain Institute. We actually have a pending motion for summary judgment and a response in opposition pending that I believe Mr. Nicolas El Campo, who represents El Paso MLB LLC, will be presenting, though I know we're within the last few minutes of your docket.
Well, I don't have a time set, but I do go home before dark. Okay, I'm sorry. So what case are you, 2024 DCV 3512?
Yes, Your Honor.
Let me see if he jumped anyone, but it's okay. No, you're next. Okay. So this is West Texas Pain versus Point Construction.
Correct, Your Honor.
Incorrectly named as Carlos Villalobos, DBA Point, El Paso MOB, fire, et cetera, et cetera, et cetera. And this is a motion hearing for a summary judgment.
Correct, Your Honor.
And are you with Kurt Paxson?
Yes, Your Honor.
Who?
Nicolas El Campo on behalf of El Paso.
Okay, okay. I can't. I have to look for you because I'm not familiar with the screen. I see you down here at the bottom. Nicolas El Campo. All right. And then is there anyone else here on this hearing?
James Skelton for Point Construction. I am here to observe. We have no position on either motion.
Okay.
And
You're
Matthew
here
Loving for
for
EP Trident.
Pardon me?
Matthew Loving for EP Trident. I'm also here.
No. Who's here for this? I can't see your lips moving. Who? James Skelton. Oh, for Point. James Skelton for Point Construction. Okay. Mr. Skelton, do you have a position on the matter, or you're just an interested party?
Oh, yeah, I'm just here to observe. We don't have a position on either motion.
Okay. And then, who did I? Okay. See, now I can't even see you because I got a screen covering your name, sir. I'll tell you who. Matthew Loving. Who you're here for? Whom?
EP Trident.
Okay. There it is. EP Triton Fire Protection. And you don't have any position on this matter. You're here to observe.
Correct.
Okay, thank you. That's another reason why sometimes it's easier to have live hearings, but this is still more convenient and quicker. And then who else is here that hasn't, Ms. Blanco, are you here in this case?
Yes, Your Honor. Alessandra Blanco and Diana Hernandez for Grace Property Consultants, LLC. We also do not have a position on either motion today.
I don't see Grace Galvin. Okay, Point Construction, Carlos Villalobos, DBA Point Homes, El Paso MOB, El Paso Trident, Pinecroft, and Pisula Development. Who are you representing?
I'm sorry, Judge, are you talking to me?
Well, I think so. Who are you representing?
I'm still waiting.
I'm here for Grace Property Consultants, LLC.
Oh, okay. Grace Property Consultants, and you are Alessandra Blanco.
Yes, Your Honor, that's correct.
Thank you. And then who else is here? That has Nicolas del Campo. Did I already account for you?
Yes, Your Honor. I'm here on behalf of Mr. Kurt Paxton.
Oh, okay.
Paso
Who are
MOB.
you representing?
El Paso MOB LLC, Your Honor. The movements in this case.
That's MOB. Do you guys have the same docket sheet I have? I can't tell with all these names. Nicolas del Campo.
Your Honor, and this, if I may address the court, this is Ansel Escobar for the plaintiff. This matter was consolidated with another matter that has another plaintiff, BHS Physicians Network Incorporated, doing business as Providence Medical Partners and Tenet Hospitals Limited. There was an order of consolidation that was signed on June 12th, 2025. So
Did
I
signed it?
Yes, Your Honor, you signed
Okay.
it.
Okay.
So you may have a long list of related parties, and you may have different captions or
And
case
I only have
files
one
in
cause
front of
number.
you.
I have Raiz Federal Credit Union. I only have one cause number right now.
Good. Hello, Your Honor?
Yes.
Carlos
That's right, Your
Maldonado
Honor.
here for Raiz. This is for a different case.
Yeah, no, thank
2025
you.
DCV 4395.
Yeah, sorry for the confusion.
No problem, sir.
Thank you. Mr. Escobar, I only have one cause number, 2024 DCV 3512. And
That is correct, Your Honor, and that's because
Where-
the other case that was consolidated with this one has been joined to this cause number. Your order of June 12th, 2025 consolidated prior cause number 2024 DCV 3721 that was pending in the 120th Judicial District Court. It was consolidated into your court, and so now it bears the original cause number from your court, 2024 3512.
so it's consolidated by order. It was in another court and it got transferred over here. And that cause number doesn't need to be on my docket. And you're representing,
I'm representing one of the plaintiffs before Your Honor. I represent Plaintiff West Texas Pain Institute, PLLC.
okay. And then who got consolidated in? What party and what's their name?
And so I know that another plaintiff was consolidated in, and there was separate matters, right, to be clear, where West Texas was not a party. That separate matter was the plaintiff was BHS Physicians Network Incorporated, doing business as Providence Medical Partners and Tenet Hospitals Limited, and they are represented by Mr. Marcos Hazan Cohen of Cousin O'Connor. And I saw Mr. Hazan Cohen on the Zoom earlier, but I believe he may have gotten off probably due to conflicting obligation, but that's speculation on my point.
Yeah.
On my part,
That's
rather.
another thing about Zoom. You can't just walk out without telling the judge. I'm just being facetious, but If you've been sitting and listening to me on other things regarding Zoom, I was just expressing that. Okay, so tell me, if it's been consolidated and it's not on my docket, can I proceed here without Mr. Marcos Hassan Cohen, or should he be here? Does this matter at all? Go ahead.
My apologies, Your Honor. I did not mean to speak over you at all. Sometimes with Zoom, it's a little bit difficult to tell when someone's speaking.
I'm trying to find out.
Right.
Did you
And
hear
so
the question?
I can't speak for Mr. Hassan Cohen, of course. We don't represent the same plaintiffs or parties. And I've not spoken with him about this particular hearing. I'll be candid with the court. He did not file any kind of responsive motion. I don't know what he would represent to the court as to whether he has a position or his client has a position on the proceedings that are before you today. All I can tell you is that there was a consolidation. We don't have all counsel who represent the parties present here today, but this primarily implicates the interests of my client, El Paso MOB LLC, and the interests of Mr. Del Campo's client, which is El Paso MOB LLC.
So, if we were in federal court, everybody would be here. That's what I'm told, okay?
I have just as much respect for your forum as for federal
No,
court.
I know. I'm just saying. Maybe it's not a question of respect. I'm just saying you want me to move on something. Not everybody's here. Is everybody waiving the presence of that other person? Or, because you said he was even here and he had to leave? Or how am I supposed to handle this? Because you want relief, right?
Well, yes, I do not. I'll let Mr. Del Campo speak because I am not the movement.
Okay,
I am
Mr.
the
Del Campo wants
respondent.
relief. And he's been laughing at some of my jokes. So go ahead, sir.
Well,
What's the
Your
nature
Honor-
of the relief?
So, Your Honor, we're seeking summary judgment. This is a dispute that arises out of a sprinkler malfunction where plaintiff was leasing the building from my client. Within the contract, there are some disclaimers as to the damages and as to the rights and obligations of the parties. And one of the sections specifically disclaims what the damages that plaintiff is seeking in this case. So we can proceed because this is strictly a contract issue, assuming Mr. Escobar is okay with that. Because he also did file a motion for continuance along with his response.
Okay, but the motion for summary judgment is against which party?
It's against El Paso MOB, Your Honor.
And
No, it's
Paso
against West
MO
Texas Pain Institute, I believe.
Yeah, yes, I guess West Texas Pain Institute. It's brought on by the landlord El Paso MOB LLC against the tenant.
Okay, is El Paso MOB here? Yes, somebody was.
Yes, Your Honor, that would be me.
Okay, and then Mr. Escobar, who just told me he can't speak for some people or whatever, but you're the relevant party because you're the movement.
I am not the movement, Your Honor. I am the respondent. So I am opposed to the
you're the
motion for
respondent.
summary
Okay.
judgment.
Okay, I'm getting someplace. So Mr. Del Campo filed it, and you're the respondent.
Correct, Your Honor.
So it's okay with both of you if I proceed without the other parties, because they're not. The motions do not address them in any way.
Correct.
It would
Okay.
not implicate their interest, correct.
Right. Yeah, we got to be careful, Mr. Escobar, when we're lawyers, right? We can't just say stuff. We got to qualify everything. I got
Agreed,
it.
Your Honor.
Good law school. Where'd you go?
Baylor, Your Honor.
Ah, it is a very good law school.
Well, thank you, Your Honor.
Well, they've always been famous for having concentrating on litigation, but that was in the old days. Who knows what they're good at now? All right. What's the basis of the motion for summary judgment, please? Move it.
Your Honor, so this case arises out of a sprinkler malfunction on August 13, 2022 that caused some damage to plaintiff. Some of the damages that they're seeking are strictly waived by plaintiff on the lease agreement, section 24, which specifically states landlord and tenant each waive any and all rights of recovery, claim, action, or cause of action against the other and its partners, if any, and the agents, officers, and employees of other party or its partners for any loss or damage, subsection A, to the premises, the building, or any improvements thereto, or any personal property of such party therein, by reason of fire, the elements, or any other cause which could have been insured against under the causes of loss special form property insurance policy, which the tenant is required to carry by the terms of this lease, or arising of subsection B, arising out of any business interruption, including but not limited to loss of profits by reasons of fire, the elements, or any other cause, regardless of the cause or origin, including the sole or concurring negligence of other party or its partners or the agents, officers, or employees of the other party. Or
Okay,
its
Mr. Escobar, let me stop you there real quick, please. Not Mr. Escobar, Mr. Del Campo. So, Mr. Escobar, are you, is your client subject to that contract or agreement? I'm not saying on that term. Are they subject to it or party to it?
Yes, we leased unequivocally. We are a party to this lease agreement, Your Honor. Although
Okay.
I certainly have a response as to the application of that particular clause.
No, right.
especially
Well, I'm going to
when
get
read-
there. Give me a chance. Give me a chance. I'm going to get there. Okay. So he could read on, or maybe he was almost through, but
He was
everything
close
that
to
he
through, I
read.
think.
Pardon me?
I think there was just a little bit more to it, but I think he was close to
Well,
through.
I
But
know.
my
I'm
apologies,
telling
Your
you.
Honor.
I understand that. Let's move on until I have a question about it, or, I need to go look it up exactly right here, exactly what is meant. So why aren't they entitled to a motion for summary judgment based on your participation or your client's participation, in that agreement? Why are they not entitled? What's your defense, or why doesn't it apply?
Because it needs to be read in harmony with additional clauses in the contract that specifically discuss waivers and releases. And I can show those clauses to you on share
No,
screen.
I
if
know
Your
you
Honor
can,
would
but you also filed your objection, right?
I filed a response in opposition.
A
Yes, Your Honor.
response, yeah. Okay. So it itemizes, or it has all of those, your argument that to interpret that, it has to be harmonious with other clauses.
Yes, Your Honor. There's a clause that specifically says
No, I'm not
that
asking you if there's a clause. I'm asking you, that's what you're saying.
that is, and that's in my written response.
Yeah, you're saying, yes, those provisions are in there, but he's only reading without including these other things that harmonize and nullify our waiver to what you're talking about.
Yes, subject to our motion for continuance, because there have not been any responses to discovery for over a year. They were served on January 8th, which was the day that our response was due.
Okay, let me do this. Okay, I'll take up the motion for discovery, the motion for continuance, and the discovery controversy after I take care of this. So all of that is itemized. And then Mr. Del Campo, did you file a response to his response?
Your Honor, the motion for discovery, there's nothing pending.
No, I'm not asking about the motion for discovery. I'm asking about the motion for summary judgment.
Well, Your Honor, we filed our motion. We didn't file a reply to Mr. Escobar's response, but we filed.
No, I know that. Okay, sir, I know that. Sometimes people do, sometimes people don't, and there's nothing wrong if you didn't. So you're filing a motion for summary judgment. He responded to it. And then I need to rule on that because you didn't have a response and everything was timely filed.
Yes, Your Honor, everything was timely filed. May I address Mr. Escobar's point in his response? He mentions that there has to be in correlation with another motion, with other clauses of the contract. However, he also brings out MOB.
Okay, sir.
Yes, sir.
Excuse me. I know. Please, it's late. Please don't. You're being very respectful. Okay. In order for us to be able to do this through Zoom, I'm just asking you to bear with me on the specific questions so that I don't have to schedule this hearing live in my courtroom in front of me, where I can be more effective in trying to get this information out. If you give me some leeway to try and take these steps to get to where you want me to get to, or at least where I need to get to proceed further on what you have to say. So when you started to argue about his representations to me, I'm not listening to argument right now. I'm trying to understand the transaction.
Okay.
You understand that? Okay.
Yes, Your Honor.
All right. So I have before me a motion for summary judgment with a response, and everything that is relevant on your arguments and your case authority, etc., is in there.
Yes, Your Honor.
Okay. And then, is there anything that you now want to argue that it isn't explicitly in there, but ought to implicitly be considered or ought to be taken into account? And you want to clarify something because Mr. Escobar made a representation to me.
Well, Your Honor, I don't understand what representation Mr. Escobar has made. He just stated that they have to be read in harmony with other clauses. He has not been pointed to any other clauses that need to be in harmony with, as well as there's some the causes of actions brought against my client. There is no cause of action for a failure duty to maintain the property, which is an argument that is made in Mr. Escobar's response. Now, the damages that are sought they fall within the clause that I referred to the court.
Okay. Let me ask you this. You can write on your pleadings, okay? But you could have also responded to your argument about that so I could take that into account. I'll try and read that into everything that you wrote. Or I will give you 14 days to file a response on my special permission for you to do so if you desire, and you think that it will help me make a better decision, regardless if it's in your favor or in Mr. Escobar's favor. Or I can set this live if you want me to set it live, and you tell me that. And all of these observing lawyers, I will excuse them if they don't want to come all the way to El Paso, if they're not here, or if they can't make it down to the courthouse. I will excuse them if nobody objects and they call in or let me know. So you tell me what I should do so that I can handle this in the fairest manner that I can under the circumstances that we have a Zoom, we have a very complicated case, we have an intervention on another case, and it's already past 5, and we've been here a long time. So tell me what you want.
Well, Your Honor, I believe based on the rush from the court, we should give me the opportunity to reply in order to address these points since
you have 14 days. I'm giving you that permission to reply 14 days. And if Mr. Escobar wants to reply to your reply, he will have 14 days. If in 14 days you haven't done that, fine. But I'm not going to be checking to see if you filed or not. So I have to get another setting, or I need some way for you to get a setting and then cancel it because you did that, so that I'll know to go pull and read and carefully take into account all the arguments and all your counter arguments.
That sounds great, Your Honor.
Okay, Mr. Escobar, it's fine, right? We're all lawyers?
Yes, Your Honor. I just had a thought that that we could prepare a proposed order that had that briefing schedule that you just mentioned and a conditional hearing to
I'll
be
do
set.
that. You civil guys like to put everything in writing. I'll do that. Did you hear I'm board certified in criminal law and I do a lot of criminal cases. But you give me an order and I'll sign it for scheduling, and you already heard the parameters.
Yes, Your Honor.
Yes, Your Honor.
And then also when you just call Robert for the new setting for the motion on your motion, where I'm sitting down, I know everything, and we have everybody here. Or if anybody wants a live hearing, I'm on the 6th floor of the courthouse.
Thank you,
Understood, Your Honor.
Have you all been to mediation yet?
No, Your Honor, and to broach that topic, we do not have a discovery control order or a trial date yet. So there's been no mediation order, and in fact, the parties have kind of deferred much development beyond written discovery because they were waiting on consolidation. And actually, recently there was a change in counsel. Susan Forbes left and was replaced by, I can't remember which counsel, but there's just been a lot of procedural developments, Your Honor. But I think we're finally at a position where we could potentially get a trial setting and develop this case on a certain schedule.
What level of a discovery are we on?
This is a level 3, Your Honor.
Level 3, okay. So, pardon me for being remiss. I don't have an automatic scheduling order because usually the parties sign off on one and either file it or they're going to follow it. But if you want me to sign a scheduling order, please submit it. Because I don't.
Agree to one.
Pardon me? Yeah, I mean, submit it. No. It's no need to buy. It's me. It's on me. Submit it, and if anybody objects to it, set it for a hearing, and I'll hear the objection. All right. Let me tell you the utility of that for me. It has been my experience that a lot of times the lawyers are able to work out everything without reaching the formality of having everything in a hearing. And I often defer to that to get resolutions of the cases. But given the number of parties, and if there's no, and without having gone to mediation, if there's no consensus of any kind of an agreement, let's just cut through that, and you go ahead and prepare the order for me to sign, send it to everybody, and I'm going to sign what you send unless somebody got a copy of it and they object to it. Anybody that wants to send me an order. Okay. The other thing is, let's talk about the mediation. Everything that's in here, because I consolidated a case, it's all going to be you still kept the same cause number. You don't even refer to the older one. And so there must be an order transferring the older, consolidating the older case into mine. But all that means is I'm going to try them both together. I think I still need the order of the old one. But you all correct me because you're the civil you're the civil experts and all. And if I don't need one, that's fine.
I believe that all parties have been joined into one cause before Your Honor, and there are not any tandem proceedings.
I know, but how is it that later on this is all going to get referenced on the old cause number? Even for a title policy, for example, somebody's looking for a particular cause number and it disappeared, depending on the transfer order language. Because if it got transferred, I'm assuming that the forum judge of the other case is the one who transferred it to me. I don't take cases from other courts, and they don't take them from me.
Yes, Your Honor. I believe there was a recusal of, I can't candidly, there was a motion for consolidation is what it was. One of the parties believed that it was the same issues and controversy essentially. And so to my understanding, what has happened is all parties and causes have been joined into one action before your court. And anybody who was looking, and I don't believe any title policies or real property are implicated.
No, I'm giving you an example of
I understand
the
it. And Your
system
Honor,
that
that's
we
a good
have for
question. How could
accountability
somebody
and cause
find?
numbers.
Right. And I believe, Your Honor, that someone who was doing their due diligence would find that there was previously a matter in the 120th, and it terminated by way of an order consolidating that with this cause number. So I think any third party, even if they were foreign to the suit, would be able to kind of trace that procedural history and see that all parties were consolidated into this matter.
All right. So you could please continue to educate me, okay? Two different courts have something that needs to be consolidated. If I was transferring my case to that court, I would sign an order transferring my case to that court. And the clerk would reassign the court number and would take the whole clerk file over to that court. In this particular one, I'm recalling, or it got transferred over to me. So somebody's case XYZ in the 120th court, the judge in the 120th court sent it to me, and I'm supposed to have a file, both files now. Because when you say that they're subsumed one with the other, I don't see how that's done. Did somebody write down and polished a combination on the pleadings of the allegations?
Well, Your Honor, and I'm a little bit remiss in the sense that I am not the movant on the consolidation. I cannot recall at this time who the movant was, but so I'm not briefed exactly on the case law and the procedural niceties. I anticipate there must be some mechanism.
Okay,
for you
hold
to
on,
obtain
hold
that
on.
prior
If you're
file.
not, I'm sorry, if you're not, that's fine. Unless anybody wants to specifically answer that, I'm going to have to continue this hearing, and I'm going to ask Robert, my court coordinator, to track down what's the old case number.
Are you asking for I can give it to you right now, Your Honor.
Yeah, I'm asking for it.
Okay, my apologies. Let me pull it up here. The old case number was 2024 DCV 3721.
Okay, Robert, can you pull that up and see that it exists? Please, and let me know if it exists in the system and what court it's in.
Yes, sir.
Your Honor, may I speak?
You may. Anybody that can help me or inform me or needs to speak, please.
It was in the 120th Judicial District Court, Your Honor.
Okay.
And it was filed by Joe L. Carrion and Destiny Glover.
Okay.
It was filed, I don't have, October 30th, 2024, from what I'm seeing.
Okay.
So the movements would have been EP Trident Fire Protections. That would have been
hold
Hermes
on.
Law.
Just please don't confuse me, and please stop talking when I ask you to hold on. Okay. But they're not. None of the lawyers are here for those parties in that cause of action.
Your Honor, I am from EP Trident and I am here.
Who's that? Oh, thank you. And Mr. Loving, is anybody else here that you recognize from those parties, or you're the only person here? And were you the only person who had an appearance in those pleadings?
I'm the only person from my client.
Right. There were other lawyers, right?
There were, yes. There was Joe, he's still on the case, and then Destiny, she's at a different firm now.
Okay, so have they been if it got sent over here, am I supposed to handle it as a separate case, or is it joined?
From my understanding, it's a consolidated case, and there's no pending separate matter out there.
Okay, a consolidated case means that they have been joined.
And my understanding was that that we're operating on the single cause number. I'm not gonna say that I know everything about the court's procedures, but that's my understanding, and that's what I have in my file.
Okay, so if we file this lawsuit and the original petitions would be like separate they're all under the same cause number, so the lawsuits are going to be part 1 and part 2, the original petitions. We go to a jury trial, and I read the cause number to the jury, and I'm only going to read one, and it's only going to be this style, or is there further styling on the other lawsuit that got transferred to me?
Judge, this is Robert.
Yes.
On the one you had me look up, it's consolidated and closed. So it's no longer in the 120th, it's consolidated into this case. I'll print out the agreed order for you right now.
Thank you. just on what he said is, if it's consolidated and closed, and all these parties are here, the pleadings on this case are the pleadings from the case that got consolidated. Is that correct?
My understanding that the pleadings in this case are the pleadings that we're all here, is in the case that we're all here about.
Okay. So after it got consolidated, it's because it was the exact cause number, the exact cause, and the pleadings in here name everybody, including the consolidated people.
May I address the court, Your Honor?
Please do. Anyone that can, yeah, go ahead.
So you do have two pleadings that fully encompass all the parties at issue, but they're by two different plaintiffs. Just like if you had any multi-party case, right? You have two plaintiffs at issue here, and if you look at the pleadings by my client, West Texas Pain Institute, they encompass all of the defendants. And then if you look at the pleadings in the consolidated case, the petition that was filed by BHS Physicians Network, the other plaintiff, when you read those in concert, that should encompass all of the defendants and all of the parties at issue.
I agree.
That is correct.
Your Honor, this is James Skelton for Point Construction. I'm new to this file, so I am right now checking to see where we are and all of that. I assume that what the other attorneys have represented is correct.
Mr. Skelton?
Yeah.
If you can sense what is confusing me, please educate me so that I won't be confused and I can finish this hearing.
All right,
what you think is like, Judge, you just don't get this. Please explain to me.
Well, I just happened to pull up defendant EP Trident's motion to consolidate, and this was
I have the agreed
filed-
order. I have the
Okay.
agreed order.
All right, so what I'm saying is the gentleman, I don't know if Mr. Loving signed it. Hang on, let me look at this.
It's not my name on it.
Joe.
Okay,
Carroll.
it is
Joe.
it is agreed by Valerie Auger,
Yeah.
Ansel Escobar, Joe Calderon, Destiny Glover, Hermes Law Firm, Susan Forbes, Marcos Hassan Cohen, Mitchell Moss, Alessandra Martinez, and Kurt Paxson.
Okay, so what I'm saying is, just looking at this now for the first time, it does appear that the party that filed the motion is here. Mr. Law and Mr. Loving is representing them. I think you're okay handling this as one case with two plaintiffs.
Okay,
Correct.
so that any orders I enter is going to apply to everybody, including on the subsumed case or the transfer case. Or
Does anybody know if if the style has been amended at all or changed to reflect the consolidation?
I don't believe there's ever been a motion to amend the style of the case, and the motions before the court, unfortunately, use an old style in the case caption. So it would probably be helpful for the court to have an agreed upon style of the case.
the order agreeing, the agreed order, the style is BHS Physicians, and I don't find them here, I don't think, on my docket sheet as a party on the docket sheet. 5-star automatic fire protection. There's Trident, but not 5-star. But and then this particular order, styles plaintiffs and counter defendants, defendants and counter plaintiffs, cross third party plaintiff and cross third party defendant. And you all are styled that way, and you still remain designated that way by your, as your clients?
We're a primary defendant, so I'm not going to answer that.
No, well, I mean, that's the point. I want to understand what's going on.
Well, may I show you, Your Honor, when I look at the civil records online in EP County, how the case shows up on epcounty.com?
No. What counts and matters to me is my docket sheet, and that doesn't match the transfer order, and the transfer order doesn't say that the case is to retain these parties. It just has them in the style.
Your Honor, I can represent to the court, I can only speak for myself, but I have no problem coming up with an agreed motion to change the style and kind of however it would be helpful, and we can get that done tomorrow.
Yeah,
Okay.
point
As far as my
construction is
court orders
is Ray, I wouldn't
the
mind
court-
going ahead with it with that understanding.
The court, oh, you want me to resolve this and you're going to do, okay, that's fine. That's fine. Nobody's objecting to that. That's fine. Let me get back to my line of my procedural line. So I'm giving somebody time to file a response, and then anybody else that wants to file a response to the response on the motion for summary judgment in whatever capacity you have standing to enter into this particular controversy can file that, and you're going to have a total of 4 weeks for that to get done. And then somebody is going to provide a scheduling order that, subject to everybody's approval, you want my signature on it, I'll do that, and that'll be the court's order. Now, there's a discovery component that you brought up. So how has the discovery been complicated, or is that in combination with anything we've already discussed? Who is saying that there's no discovery, even though we haven't filed any motions, or what's going on, please, on the discovery?
Your Honor, I have a motion to compel that's pending against El Paso MOB LLC, but I'm not making any arguments about discovery as to relative to consolidation or anything like that. And I don't believe that the motion to compel was set for hearing today, though I may be mistaken.
But there's never going to be I got all these parties, and there's never going to be synchronized accountability for some of these very standard procedures. If you all will agree to a scheduling order and you put deadlines, it'll be from the date that you file the agreed scheduling order. And that's when I'm going to start the ticker on whatever requirements there were or deadlines there are under the code for discovery. Because I'm not going to leave it open for whenever, my discretion is not going to be, like whenever you all get to it. So you all agree to that. If you want to move your case efficiently and file a discovery order, and if I need to approve it by signing off on it, I will.
Understood.
And I'll give you 2 months to do that, unless somebody wants to rush faster. You don't have a setting for a jury trial yet, right?
No, Your Honor.
Okay, so once we have that discovery order and deadlines that are statutory, or per your order, you can put specific dates. That's got to get closed off, and I'm going to order mediation within 60 days of that order. But some of you are saying, well, we're not a part of this and a part of that. So I'm probably going to have to get a status hearing to be real specific about who has to mediate with whom, instead of just filling the mediator's office with all of you.
Well, Your Honor, a suggestion, might we just put an agreed mediation deadline in the discovery control order?
Go ahead. This case ends up being what kind of case? Because I do assign who the mediator is.
It's a premises breach of contract and negligence case. It doesn't implicate any personal injury. It's all about injury to actual property.
I'm ordering mediation with Carlos Cardenas. If nobody has any objection to that.
I don't want to agree to that, so I'm going to just do a formal objection just because I'd like to consult everybody to make sure we have a mediator we all agree can be effective. That's
Well, I'm asking you now.
That's right. That's
I'm not
why I'm
asking
saying.
you. Listen, Mr. Loving, I'm not asking you to be in charge of that.
Okay, I'm just saying you asked if we had any objections, and I'm saying I have
Let
an
me do
objection.
this. Let me do this. Carlos Cardenas is the assigned mediator within that amount of time. And if anybody objects to him, file your objection, and then, I'll appoint another mediator. Okay?
Okay.
I don't want to change this to a democracy and y'all vote on that kind of stuff and all. I'm trying to get away from that just so y'all, with all these cases, have standard orders that you all are operating under. So it's going to be Carlos Cardenas, and then if there's an objection to him, there'll be another mediator that I'll appoint.
Understood.
And probably the second mediator is going to be who I appoint regardless of the objection. unless there's a bona fide conflict or something that's brought to my attention.
Yes, Your Honor.
It'll probably be Chris Ancliffe or somebody like that, but
I think Chris Ancliffe would actually be well suited to this case. It's a complex commercial case, Your Honor.
I understand, Mr. Escobar, but I already told you, I'm not here to be convinced or whatever. I already heard somebody disagreed with me. My order is Carlos Cardenas, and if you don't want him, I'm going to appoint someone else. I happen to mention that it might be Chris Ancliffe, who was the preceding judge in this court and does a good job, but I may not send it to him. You may not be aware, for example, if he's got a backlog and I have an issue with that and all, I'm going to exercise my discretion and appoint somebody responsible to be mediator. Mr. Skelton, am I being too mean?
I don't think so.
Okay, I'm sorry.
You're
It's
fine.
late. It's late. Anything else? Oh, so you're gonna file those motions and counter motions, and then somebody's going to file a motion for the new styling, and then we move on from there. I'm going to look at all the pleadings just to see how they're going to get consolidated for if and when we go to trial. How they're going to be, because I'm not going to have prayer 1 and prayer 2 and stuff like that, or I might. I just need to see how practical or impractical that is. What is really complicating all of this stuff is a consolidation, which I'm not opposed to, but there's so many parties, so it's I want to see if there's an aberration in how stuff gets presented when it gets consolidated this way. Anyone else? No? Should I excuse you, or do I need to take up any other matter or go on the record or do whatever? Okay. Thank you very much. You're all excused.
Thank you, Judge.
Thank
Let
you.
me see who's left. Raiz Federal.
Yes, Your Honor. Good
Hey,
afternoon, Your Honor.
Mr.
How are you?
I'm good, thank you.
I'm gonna try to make it fast and sweet for you, Your Honor. I know you've been very busy. And we
Oh,
appreciate
a writ of
your time.
sequestration. Okay, so
Yes, sir.
and Carlos, are you here for Carlos Miranda?
Yeah, I'm his law partner, Your Honor.
Okay. Well, Carlos and I go way back, and
Yes, sir.
I'm familiar that he doesn't file dilatory pleadings or whatever. What do you
Correct,
want to
Your Honor.
sequester?
And actually, I did have the pleasure to meet you back when I was an LSPI, when your daughter was an LSPI.
Oh,
She's a year older than me. And when she went to UT Law, and then I went to LSP, I went to law school after that. So, yeah.
okay.
Yes,
Well,
Your
I'm
Honor.
biased, and she looks 5 years younger than you. Okay.
Yes, Your Honor. So I'm gonna make it short and sweet. Hopefully,
Please.
you can go home, Your Honor.
Yeah.
If I proceed, this is Carlos Maldonado on behalf of Raiz Federal Credit Union.
Yeah, we're not on the record, but go ahead.
Okay, well, thank you, Your Honor. We filed a lawsuit against Dania Valles on September 29, 2025 for breach of contract and request of writ of sequestration. Mrs. Valles entered into a contract agreement with Raiz seeking a loan agreement for a 2017 Chrysler 300, which she still has in her possession. The reason that Raiz is asking for this is because as of today, the defendant owes Raiz about $3,600. She has not paid since June
Okay, let me ask you this.
2025.
Does she have
Yes,
notice
sir.
of this hearing? Does she have notice of this hearing?
No, she does not, and because she's not required to have notice of this hearing,
Okay,
since it's a
granted.
writ of sequestration, Your Honor.
Granted,
Oh, thank you.
submit it to Robert, and
It has
if
already been
there's
submitted, Your Honor. Was submitted.
well, okay. If you already submitted it straight to Robert, it'll get signed. If you're not sure if it's straight to Robert, please send it to Robert, and it'll get signed.
I think it was. Let me
Okay.
just to want to double check if Mr. Robert can be kind enough to provide me with
No,
his
no,
email
no, no,
address.
no, 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 no. Listen to me.
Yes.
Send it. Just
Yes,
send it to him.
it has been sent, sir. Yeah. Yeah.
Okay,
I
even
can
if it's
confirm.
repetitive, even if
Yes.
it's repetitive, send it to
I
him.
will send it to him right now, Your Honor. Again.
Okay,
No
give my
problem.
regards to Mr. Miranda.
I will do this, sir, Your Honor. Thank you so much, and we are definitely gonna miss you once you're off the bench.
Oh, thank you.
Thank you,
very
sir.
much.
You have a wonderful day. May I be excused?
You may. Thanks.
Thank you, Your Honor.
They
Have a
taught you
wonderful day.
well. Whatever
Thank you, sir.
school Alex PI sent you to, where'd you get in?
I actually only was able to get into a couple of schools, but I went to Oklahoma City University, Your Honor.
Well, that's a good.
Yes.
I've heard good things about them, and there's a lot of good lawyers out of there. So
Yes.
it's not just.
No, yeah, I'm happy to, immigrated from Ecuador and coming to the States and being able to be a lawyer here. So I'm pretty
Good for
happy that I
you.
was able to do it, Your Honor. So
Good for you. Okay. Thank you
thank you
very
so much
much.
for your time, Your Honor. May I be excused?
You may. Thank you.
You have a wonderful day, okay? Thank you, Your Honor. See you
Thanks.
soon.
Okay.
Bye-bye.
Bye. Everybody's excused. Thank you.